Good afternoon. Welcome to Webb County Court at Law 2. I'm Victor Villarreal, judge of your Webb County Court at Law 2. This is the family law docket followed by the probate, guardianship, and civil docket for Tuesday, March 17, 2026. The time is now 1:56. Court is now in session. Assisting us today are Cecia Rodriguez, court administrator, and interpreter is Mr. Quig. The coordinator for the family law docket is Ms. Cynthia Flores. The coordinator for the probate docket is Ms. Gloria Noriega. Video conference co-hosts this afternoon include Mr. Cordova, Ms. Noriega, Ms. Ramos, Ms. Cuellar, Mr. Hernandez, Ms. Rivera, and Mr. Lopez. These proceedings are being electronically recorded. Everyone is instructed not to record any portion of these proceedings. Only a court reporter may provide the official record. As with all proceedings, violation of these instructions are subject to contempt hearings. If you're joining us online, you're instructed to act as though you were in court, because you are in court. The rule here is simple. If you would not do it in person, don't do it online. For example, do not operate a motor vehicle. There's no smoking, no chewing gum. Wear appropriate clothing, and always exercise proper courtroom decorum. The court will call the family law cases first, followed by the probate and civil docket. Just know, counsel, that for the temporary restraining orders and temporary order settings that are not a first setting, if you don't move today, they will be denied. Ms. Flores, Ms. Rodriguez.
First on for the family docket, page 2, number 5.
This is Gerardo Gutierrez versus Raquel Gutierrez, cause number 2026 FLB 187C3. Good afternoon, Ms. Aldana.
Good afternoon, Your Honor.
Court marks you present by video conference. Ms. Garcia, are you present?
Your device was noted present, Your Honor, but I don't see it anymore.
Court marks Ms. Garcia not present. Ms. Leticia Garcia. Gerardo Gutierrez, Raquel Gutierrez, are you present? Court finds the parties are not present. Ms. Aldana, this is the second setting.
Yes, Your Honor. The parties have conferred and reached an agreement. We filed a Rule 11 with the terms of that agreement this morning, a little while ago.
The court was unaware, which means it hasn't been processed. Let me just get confirmation from the district clerk's office that Rule 11 has in fact been filed.
It has been filed, Your Honor. We just accepted it.
Not a problem. I didn't know about it, but now I understand why. All right, the court will receive, review, and accept that Rule 11 agreement. They should be turned to formal orders. Those orders are due to the court honor before
March 30th by submission.
Wonderful. File them before March the 30th, and you'll come back for a trial on merits on May the 11th. Anything else on this case, Ms. Aldana?
Nothing further, Your Honor.
Any other cases for Ms. Aldana and the family law docket?
No, Your Honor.
All right.
Person counsel, Jose Loredo, page 1, number 2.
Oh, does Ms. Aldana not have any other cases this afternoon?
Correct.
Have a great day, Ms. Aldana.
You too. Bye.
You said Mr. Loredo?
Yes, Your Honor. Page 1, number 2.
Vidal Rene Rodriguez versus Ilse Gonzalez Rodriguez, cause number 2026 FLA 98C3. Good afternoon, Mr. Loredo.
Good afternoon, Your Honor.
Court marks you present in person. Ms. Anderson, Brenda Anderson, are you present?
Not identified in virtual courtroom.
The
Parties.
in the hall, Your Honor.
Vidal Rodriguez, Ilse Gonzalez Rodriguez, are you present? I'm going to ask that you unmute your device, Mr. Rodriguez, and tell the court, are you Vidal Rene Rodriguez?
Yes, Your Honor.
Welcome to court, sir. The court marks you present. You're participating by video conference. As you can see and hear from your device, your lawyer is present in court. Court marks Ms. Anderson present in person. Is this your client with you? Court marks Ms. Gonzalez Rodriguez present in person as well. Mr. Loredo, Ms. Anderson, go ahead.
The parties have reached an agreement. We have circulated the written orders, and I have them signed by Mr. Loredo and his client. And I'm just pending my client's signature, and I just reviewed it with her, so she should be signing shortly.
Anything else on this case, Mr. Loredo?
Nothing right now, Your Honor.
All right, Mr. Rodriguez, Ms. Gonzalez Rodriguez, this is the fourth setting, but obviously you've been working on this case between now and the last setting. You've put your agreement in writing. It's just pending your signature. If you agree to that, Ms. Gonzalez Rodriguez, after talking to your lawyer, you'll sign it. She can turn in the original here, and I will sign off on it. If nothing is turned in today and nothing is argued today, then we just go on to a trial on the merits April the 16th. Mr. Rodriguez, do you have any questions for the court?
No, Your Honor.
Ms. Gonzalez Rodriguez, do you have any questions?
No.
All right, keep in contact with your lawyers and we will see you for your final hearing on April the 16th at 2.
It's okay with the court. Could we request a May setting instead, just to kind of give it some time to, for us to exchange discovery if we need to? And also just to kind of see how the visitations go through Safe Haven.
Any objection?
No objection, Your Honor.
I think it's a good request. Give us, so I'm gonna take off the April setting. But if there is discovery, let's give it 2 settings. Give us a final pretrial hearing and final hearing dates. Final pretrial in May.
May 19th at 2 p.m.
Ms. Flores, I'll give out the dates. Your Honor, May 19th at 2 p.m.,
Final hearing in June.
June 18th at 9 a.m.
Any objection to those dates, Ms. Anderson?
No, Judge.
Mr. Loredo?
No objection, Your Honor.
All right, Mr. Rodriguez, Ms. Gonzalez Rodriguez, keep in contact with your lawyers. I wish you both very well. Good luck to all.
Thank you.
Any other cases for either counsel?
Not for the probate docket, no, Your Honor.
Good to see you both.
Thank
Have a
you.
great
Your
day.
Next online for the family docket, page 1, number 1.
Raul Agustin Gonzalez versus Liseth Lopez Gonzalez, cause number 2015 CVG 561C3. Court marks Ms. Soto present in person. Are you Raul Agustin Gonzalez?
Yes, Your Honor.
Welcome to court, Mr. Gonzalez. The court marks you present in person. Are you Liseth Lopez Gonzalez?
Yes, Your Honor.
Welcome to court, Ms. Gonzalez. Court marks you present in person. As you can see from this device, your lawyer is present and participating by video conference. Same thing for you, Mr. Gonzalez. Your lawyer, as you can see from that screen, is present and participating by video conference. Counsel, what is the announcement?
Your Honor, if I may, Ruben Arce for Liseth Lopez, Judge. On this matter, Your Honor, we had requested ad litem to be present and visit with the child in question, Judge. The ad litem has done so, Judge. I did speak to Ms. Soto in reference to a possible recommendation to the court. She does have a recommendation, my understanding, for temporary orders, Judge. I did speak to Mr. Garcia, but anyway, long story short, Judge, the ad litem's recommendation and our recommendation or request is not in alignment with Mr. Garcia's request, Judge.
So you have a contested hearing today?
My understanding is it might get to that point, yes, Judge.
Well, no, we should know by this point whether it does or doesn't. Mr. Garcia, have you been able to confirm with Mr. Arce today?
We have, Your Honor, but we haven't reached an agreement yet as to the visits. That's the only issue for today, at least for my client.
All right, this is the first contested matter on this docket.
And just for the record, if I may briefly state, I was appointed attorney at litem, so I'm not giving a recommendation today. I'm here on behalf of my client, the child. I did go back and review the court's order and it says attorney at litem.
Yeah, I mean, and the reason I say this, Mr. Arce and Mr. Garcia, because I mean, it's just a recommendation. So even if the court hears it, if there's any disagreement, it doesn't matter what the recommendation is. If there's no agreement, then the court has to hear evidence and testimony, and it's all right. Mr. Gonzalez, Ms. Gonzalez, keep in contact with your lawyers. You'll be put under oath momentarily. Do you have any questions for the court?
No, Your Honor.
All right, stand by, please.
Thank you, Judge.
Thank you, Judge.
Thank you, Your Honor.
Page 2, number 3.
Felicitas Garcia versus Brian Alvarez, cause number 2026 FLA 245C3. Jose Arce, are you present?
Not present.
Speak into the microphone and tell the court, are you Felicitas Garcia?
Yes, Your Honor.
Welcome to court, Ms. Garcia. The court marks you present in person. Your lawyer, I believe, is in the hallway. Your lawyer is not present. Brian Alvarez, are you present? Court marks Mr. Alvarez not present. He was served with process February 24, 2026. Ms. Garcia, this is the second time that we've been in court on this matter. Are you requesting anything from the court today?
No, they're actually, we came to an agreement. I think he was just, my attorney was talking with Mr. Alvarez.
All right, I'm going to place this case on hold. I'm going to begin the next hearing. Please tell your lawyer to come into court very soon. All right, this is the second contested matter on the court's docket.
Page 2, number 4.
Patricia Ornelas versus Jose de Jesus Ornelas, cause number 2026 FLB 152C3. Mr. Figueroa, Antonio Figueroa, are you present? Court marks Mr. Figueroa not present. Parties, Patricia Ornelas, Jose de Jesus Ornelas. Any parties present?
Good afternoon, Judge.
Good afternoon.
Attorney Martinez King, we filed our notice of appearance on behalf of Patricia Ornelas today, along with a motion for an agreed motion for continuance.
Let me ask you this, are you Patricia Ornelas?
Yes, sir.
Welcome to court, Ms. Ornelas. The court marks you present in person. As you can see from that screen, your lawyer is present in person. Mr. Martinez King, this is the third time the court has set this TRO. Give the court any good reason, cause, or basis to continue this setting.
Well, the only thing we do have is that we were just hired as counsel for it, so we haven't taken a look at it. There's also a lot of documentation that was filed prior to this TRO that our client didn't receive, and we obviously haven't taken a look at it. We were able to confer with Mr. Figueroa prior to the hearing, and he was in agreement as well that it would be prejudiced if we continue with the TRO.
But have you filed any requests for relief on a TRO?
No, we just barely got hired on.
Right, so nobody is here to move on the request.
Correct.
What have you had an opportunity to confer with Mr. Figueroa about what in the TRO is agreed to or what is contested?
There is one contested matter on it, and it's going to be a matter of the exclusive use of the home. Aside from that, everything looks like it will be agreed to.
Interesting.
This is the residence of both petitioner and respondent, so it would kind of be a little bit of an issue if one person has the exclusive use. Sure.
Ms. Ornelas, the use of your marital home is an issue that you cannot agree with Mr. Ornelas on?
No. Since August of last year,
Alright.
and we've been living in the same house.
The court finds that there is good cause, reason, and basis to grant the request. All right, the request is granted. Give us another TRO setting, final setting.
March 31st at 10 a.m.
March 31st at 10 a.m. Just know that this is the last setting on the TRO. So just between now,
I have been notified even on the.
well, you're being given time, so you're not prejudiced, but
Okay.
make the best use of this time between now and March 31st. Keep in contact with your lawyer, talk to him. He's going to prepare you for that hearing. And Mr. Ornelas will keep in contact with Mr. Figueroa. We'll see you on March 31st.
So
I'm going to request that these settings be in person. So Mr. Martinez King, you, Mr. Figueroa, Mr. Ornelas, and Mr. Ornelas will be in person.
Yes, Judge.
All right, we'll see you on March 31st. I wish both parties well. Yes,
Counsel Martinez King has a case further down the line on the probate docket.
understood.
First, in person for the probate docket, Your Honor.
No,
It's-
let's go back to page 2, case 3. Felicitas Garcia, Brian Alvarez, cause number 2026 FLA 245C3. Court marks Mr. Arce present in person and his client present in person. Brian Alvarez, are you present?
Yes, President.
Court finds all parties and Mr. Arce present. Mr. Arce, what is the announcement?
Your Honor, on this matter, I don't know if the court recalls, last time we were here, Mr. Alvarez had indicated to the court that he was not going to hire an attorney. I've had occasion to meet with Mr. Alvarez that we're still trying to kind of work out details. We should be able to resolve it.
When?
So, if we can just recall this, we should be able to resolve this today.
Are you Brian Alvarez?
Yes, Your Honor.
Mr. Alvarez, do you have a lawyer?
No.
Are you going forward today without a lawyer? Yes. The court marks you self-represented. Talk to Mr. Arce. And we'll call this case at the end of the probate docket.
That'll be
Right.
fine. Your Honor.
Good luck.
Thank you.
First in person for the probate docket, Your Honor, is Counsel Reyes on page 8, number 19.
This is John Quig versus Maximo Contreras, cause number 2024 CVH 237C3. Court marks Mr. Day is present in person. Good afternoon, counsel.
Good afternoon, Judge.
John Quig, Maximo Contreras. Are any parties present?
Mr. Quig is present here in the courtroom. I'd ask the court to call Maximino Contreras. This was a case that previously we amended due to a misnomer on the names with the state of Texas.
Are you John Quig?
I'm John Quig.
Welcome
Yes.
to court, Mr. Quig. The court marks
Thank
you
you.
present in person. The person to your left is your lawyer.
Thank you, Judge.
Maximo Contreras, are you present? Court finds Mr. Contreras not present in person, not present by video conference. Let me get confirmation or affirmation from the clerk's office that defendant has in fact been served.
Verifying, Your Honor.
Thank you.
He has not been served with the amended petition, Your Honor.
That
No,
was the
actually,
issue.
he was. Judge, Mr. Maximino Contreras presented himself in person way back when, provided his email address. He physically made an appearance, and then once his email address was added to the Justware, he was served with all motions. And he's been served with everything.
Correct, Your Honor. He was e-served.
Okay, well, there it is.
It was just that he never had physically been served with process, but he appeared physically back, I think a year ago.
All right, you're set for final hearing. What is the announcement?
We're ready to proceed. It's a prove up.
Your first witness?
Mr. Quig.
Mr. Quig, would you raise your right hand? Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth so help you God?
Yes, Judge.
You may lower your hand. Mr. Reyes, go ahead.
Please state your true and correct name.
John Quig.
And you're the plaintiff in this case against Maximino Contreras?
Yes.
Where do you reside, Mr. Quig?
I reside on a ranch 8 miles south of Miranda City.
And that is here in Webb County, Texas?
It's in Webb County, yeah.
Okay. And now, did you hire Mr. Maximino Contreras?
Yes, I hired him to install some generators.
Okay, and was this agreement made directly with Mr. Contreras or an agent of Mr. Contreras?
No, directly with him.
And what did Mr. Contreras represent he would do for you?
He said he would come to the ranch, check out what he needed, and order the generators and install them.
Okay, and did you agree to pay Mr. Contreras for these services?
Yes, I did. I paid him an amount ahead of time of $10,450.
Okay, and how did you make a payment to him?
In a check.
Okay, I'm going to show you what I've marked as exhibit number 1. Are you familiar with this document?
Yes, that is my check.
Okay, and is it fairly and accurately depict the check?
Yes.
Okay, and this is the check you wrote for the installation of the generators?
Yes.
Okay, and was that check ever cashed?
Yes, it was cash.
Okay, we offer exhibit number 1 into evidence.
Submitted without objection.
And after receiving your payment, what did Mr. Contreras do to begin the project?
He said he would come out and he kept failing to come out. Finally, he came out with a very small generator, which was nowhere near what I had hoped for. And I didn't have him install that. He said he would bring the larger one, but he never came.
Okay, and you informed him directly of the improper or the incorrect
Generator, yes, I did. I told him it wasn't near the amount.
Okay, and what, if anything, did he say he would do?
He said he would get the large generator.
And what did he do? Did he ever get the large generator?
He never got it.
Did he ever correct it or come back to fix it?
No, he promised me he would pay me back when he couldn't do it. And I met with him a number of times, but he never did pay me back.
Okay. And so as a result of the payment of the check, now the check was for an amount of $10,458, correct?
Right.
And did you lose out on that $10,458?
Well, I haven't gotten my generator. Yes, I lost out.
And that is the amount that you're asking this court to grant you, correct?
Yes.
Now,
Plus my attorney's fee.
and when Mr. Contreras agreed to install the generators, did he represent you that he could provide the correct size generator that you needed?
Yes,
Okay, and was the unit that he actually gave you consistent with what he said he was gonna do?
no, it was a much, much smaller unit.
And have you completed the job since then?
No,
Okay, so you haven't been able, because of the expense, to hire somebody else to get it done?
right,
Now it is, now you said you hired and you're asking for your attorney's fees, correct?
yes,
And my attorney's fees to you as of today are $3,000, correct?
correct.
And you're asking the court to award you those attorney's fees, correct?
Yes, I am.
Okay, now all the facts that you testified to those, are those true and correct?
Yes, they are.
And is there anything further you'd like to ask the court?
No,
Or Ed? Okay. No.
you know,
Oh,
I tried to reach him many, many times. And many times he told me he would pay me the money back, but he never did. He lied each and every time.
Do I have no further questions of this witness?
Anything you want to testify to on fees or anything else, Mr.
Your Honor,
Days?
I prepared, for the sake of brevity, I prepared an affidavit. I go under oath, I guess, to be the custodian of records for my office.
Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth so help you God?
So, yeah, I do.
All right, go ahead.
Your Honor, I'm presenting to the court petitioners exhibits 2, 3, 4, 5, and 6. Petitioners exhibit 2 is the process fee of a hand delivery of the DTPA notice. Exhibit number 3 and 4 are actual copies of the notice of claim under the Texas Deceptive Trade Practices Act. Petitioners exhibit number 5 is an affidavit by Martin Baca of his attempts to serve Mr. Contreras of said claim to prove notice that was given to Mr. Contreras and his alias companies. And then petitioner's exhibit number 6 is an affidavit regarding attorney's fees. And so we're asking the court to make business records for Deus Law.
They are admitted without objection.
And we rest, Your Honor. And in closing, we ask the court to grant damages in the amount of $10,458.00, which is the principal amount that was due. We're asking for additional amount of 3 times that amount for treble damages of $31,374 for a total of $41,832. We're asking the court to grant prejudgment interest at a rate of 5%, which depending on what the court's decision is on the damages amount, it's going to take some serious math. And so I was going to hold back on that.
On which one?
Oh, the prejudgment interest,
I
because
see.
it accrues from the date of the accrual of the cause of action. We're asking court costs in the amount of $419, which in my understanding, those were the costs of all the filing fees. We're asking for post-judgment interest of 6% per year from the date of the judgment until it's paid. We're asking for $3,000 in attorney's fees, and additional amounts indicates that it's on the unlikely chance that there's a motion for new trial or an appeal. And so the total amounts, the only issue is the interest or prejudgment interest because of the date of the cause of action and today's date. But if the court tells me what the numbers are, then I can calculate the prejudgment interest to start off on. Or would the court rather me submit a Word document?
Judge, I do have another question. He did leave that very small generator. It's still in a crate at the ranch. He never came to pick it up, and I don't know if I can apply $500 against it to this to keep that, but
Well, you are under oath, Mr. Quig.
Yes.
Do you have what is your opinion as to the value of that other generator?
about $500, Judge. It's a small generator.
So what you're telling the court is that you entered into some sort of contract with Mr. Contreras for a generator valued at or about $10,400, and he delivered to you a $500 worth generator?
Yeah, well, the one I entered in the contract was the 10,000 some odd. Actually, it was probably more than that. That was sort of a down payment that I paid him because it was a very large generator to be able to handle my whole house.
Sure, but my question is, and I understand that, but my question is, you contracted for this really large amount, and in exchange, instead of giving you something similar or comparable, he gave you a generator valued at $500?
Right. Which he never did install either. I mean, it's still in its crate.
All right. In cause number 2024 CVH 237C3, the court finds that it has jurisdiction over this case. The court has now heard the evidence and testimony from witness and plaintiff John Quig. The court finds that Mr. Quig is entitled to the relief he is requesting. The court finds one question, although Mr. Theus, I was reviewing as the court was listening to testimony and including yours. For the treble damages, the court only needs to find one or the other, correct? Because I can make a finding, and I will make a finding shortly as to the economic damages, but there is zero evidence on the record regarding mental anguish. So the court doesn't need to find both, right? It's an or.
Yes.
That's a
My-
court's
My
understanding.
understanding was it was or because it's a deceptive trade practice, is
Right.
that the falsity and materiality of the false.
Sure. All right, the court finds that in favor of Mr. Quig under the both DTPA claim and the breach of contract claim. Under the breach of contract claim, Mr. Quig is entitled to $10,450 plus $3,000 in attorney's fees. The court finds that those are reasonable and necessary. Under the DTPA claim, he is entitled to the same amount plus the treble amount that the court finds is the amount that he is out, plus the treble damages that he is seeking based on his testimony here. These are the orders of the court. Those orders include court costs in the amount of $419, pre-judgment interest, post-judgment interest in the amount of 6%, and all other matters as prayed for here in open court. These are the orders of the court, and the orders are due to the court on or before
March 30th by submission.
the court has ruled on your case and granted in your favor. Mr. Quig, do you have any questions for the court?
Thank you, Judge, and happy St. Patrick's Day.
I wish you and all persons very well. Have a great day.
Thank you.
Any other cases for Mr. Theus? All right. Have a good day, Mr. Theus.
Likewise, Judge, that's all I have, maybe. Excuse me.
Yes, sir.
Next in person, Counsel Lanessa Garcia, page 2, number 4.
This is in the estate of Elias Ibanez Flores, cause number 2021 PB4 10902. Court marks Ms. Garcia present in person. Mr. Eduardo Romero also present in person. Ms. Soto was present, although was the mediator. Dinora, Brazaleta, Mayra Miramontes, Mateo Ibanez. Are any parties present?
No, sir.
Court marks no parties present. Ms. Garcia, Mr. Romero.
Your Honor, we filed an agreed motion for continuance for these reasons. I had sent Mr. Romero in January some discovery. They were supposed to be responded to in February. Were not responded to. We're coming into agreements for his client to provide responses that we need for today's hearing. Mr. Romero's client wanted to try to send additional settlement offers in the hopes of coming to an agreement, but that just wasn't possible. So we do need to proceed with the hearing, but I need the discovery responses. So that's why we're asking for a continuance. And we're conferring as to the date in which they will provide the responses and submit a Rule 11 agreement. There was just some issues that I was working with him because I'd requested personal tax returns, but I think we're going to come into a confidentiality agreement to not bother the court with that. So we're just working on those little details, and we will submit a Rule 11 agreement with regard to that production. But Mr. Romero does agree with me that the objections are waived.
Mr. Romero.
Yes, Your Honor, that's correct. Well, objections waived as to the non-personal items that we will negotiate and hopefully
Yes.
settle with.
Yeah, and I understand those, and so we still want them produced, but under circumstances to not tie up the court with time that we can negotiate something reasonable that will protect his client's interest.
So in the court's review, I'll tell you where the court's at. In the court's review, this is the third setting for final hearing.
Yes.
So in the court's review, I was going to propose several things. I mean, ostensibly, if there's no agreement, you would have a final hearing today. The other thing you can do, I guess, is or ask for the court rule by submission, although then you don't get the opportunity to cross-examine and all these things. So that's not really a viable option. The other thing is to just certify this thing complex, because the court's concern at this point is that an audit would show that there's just been multiple continuances, and I would rather there be something in the record to say, for this reason, there is a good and logical and reasonable basis for allowing the case to continue past two or three settings. So let's do a couple of things. One of you or both of you put on the record what in fact makes this case complex, one, and two, give the court on the record some definitive deadlines so that it's a valid, enforceable, on the record Rule 11 agreement, so that if the discovery isn't produced by a date certain, then it becomes enforceable. I mean, I like that y'all are talking. I just would like it to be enforceable.
Yes. I will let first, what makes this case complex? The decedent died without a will. He had a surviving spouse and children from his marriage. He also had children from another relationship, and my client represents her minor child, one of them, Alexis, I can't pronounce it, Judge. Alexis, I think. And then the two other children are now adults, Eliana and Ellie. Ellie just turned 18 in December. The prior inventory excluded most of the property in the estate. And there is a dispute amongst my client and Mr. Romero's client, the surviving spouse, as to whether or not the community property is part of the estate. And so from my client and I, and we believe under the law that anything accumulated during the marriage is community property of the decedent. He died intestate. So that involves a lot of property, corporate interests, real property, bank accounts, and all of that was left out of the inventory. So it's very important that we get all the correct property in order to make a proper partition and distribution to my client's children, whether they were born of a marriage or not, or born during his marriage to another woman. They are still his children. There is no debate about that. And they are heirs. And so we just want to make sure that we capture all the property that the estate is entitled to, and that the court must divide and partition amongst the heirs. Did I get that right, Mr. Romero?
Yes, I mean, sure. There's some objectionable properties that we have in dispute, and that's why there's a motion that was filed by Ms. Lanessa Garcia.
Sure, without verifying or ascertaining or affirming whether the factual disputes as alleged by Ms. Garcia's clients are in fact correct. That is in dispute, and that's the reason why you haven't been able to resolve it. So why don't I make that finding? So ordered. All of that, and the court finds that there is good cause, reason, and basis for this case to exceed and to go outside the Texas Supreme Court time standards. The court making that finding on review, I think everybody is in a good position in place. All right, so this case is now hereby certified as complex. Those orders are due to the court on or before
March 30th by submission.
So let me give you all some time to talk for a few minutes just to put any other definitive and specific agreements on the record. For example, the specific documents or information that will be exchanged and by what date certain. That way it's enforceable.
There were 3 sets of discovery, second request for production, second written interrogatories, and request for disclosures. Those are the 3 sets of discovery that are outstanding. So I told Mr. Romero I would work with him to give me a date that accommodates not only him, but his client to provide that information. I can tell the only other I know Mr. Romero told me that his client was going to have some heartburn with regard to some personal income tax returns. I had told Mr. Romero that we could enter into a confidentiality agreement to where it's for attorney's eyes only. So I will not be giving that to my client I may use it in court, but provide that under seal to the court. Those are just little things that we need to narrow down. If I do need to use it as evidence, how will I do that in order to protect his client's privacy? But at least for discovery purposes, it would be my eyes only and not to be given to my client. To my clients.
Well, it sounds like if this could be reduced to writing, it would certainly protect
Yes.
your client. Mr. Romero, response?
Yes, Your Honor. So I don't know if we can do it exactly right now to give it to the court, but that's why we need Ms. Garcia and I to sit down and formulate,
Exchange
yes.
the confidentiality agreement, but at least for everything else with regard to Ms. Barcelata, I'm sorry. Okay, I say Barcelata, sorry.
So, well, let me ask you
Barcelata.
this, ostensibly, this would have been resolved if this was pretty straightforward, simple, and just a
Yes.
few documents, but ostensibly, there's much more that needs to be produced. So, Ms. Garcia, what do you believe would be a reasonable amount of time? Overshoot that date, and I'm gonna do the same thing with Mr. Romero.
There were a lot of documents with regard to other companies that for which I requested documentation, but also questions answered. I would say, 30 days is what there would be. I would say 30 days because I do believe that it's going to take some time.
So here's a question to you and your clients, Mr. Romero. Obviously, I'm not gonna order anything because it's not a request that's pending for today, but I can approve and put agreements on the record. So do you believe 30 days is agreeable? Is it completely not agreeable, or do you have a different proposal?
I would say a little bit more, Your Honor, simply because if we say 30 days, we're looking at around mid-April, which is if I'm gonna need the assistance of an accountant, they're gonna tell me that they're busy. So I would
Yeah.
say by either the end of April or the beginning of May, just to be on the safe side.
Beginning of May is fine, Judge. I'm not going to belabor that point. We want to get the information and we want to get it correct and complete.
All right, there it is. So let me do this. 2 orders due to the court. First is the order that has now certified this case as complex for the reasons stated on the record. And 2, that's due to the court on or before March the 30th. Just turn in a pretrial guideline order to the court before that date. That way that gives you some parameters.
Okay, so with regard to pretrial, because the objection to the inventory is just one thing. There could be other issues that come up. So with a pretrial guideline, what is it that we're shooting for? Is it for that motion?
A final
Okay.
hearing.
Okay. for that.
Subject, because it's a hypothetical until it happens. So unless
Okay.
there's another request for relief, we can't presume that it's gonna come
Okay.
in. If it does come in, we'll consider it at that point.
Okay,
So the certification of this case is complex. And the pretrial guideline order, March the 30th, and the court has pretrial guideline
Okay.
forms. Anything else on this case, Ms. Garcia?
no, sir. So I guess the motion for continuance,
Is granted.
granted.
There's still written one filed with the clerk or handed. Would you
was a-
like one?
It was e-filed today.
There was one e-file, Your Honor. Probably before lunchtime.
I
That's why the court hasn't,
I apologize, Judge.
Hmm.
We're trying to work things out.
not faulting anyone, just making observations, so. All right,
We will print out for your review, Your Honor. If anything's missing, I will send orders due or something due by the 30th as well.
Okay.
now, as part of the pretrial guideline order, put in a second mediation with Ms. Soto.
Okay.
She already has information on the
Yes.
case, and after the exchange of information, perhaps that'll get you, not you, your clients to a better place.
Okay.
All right, good luck to all.
Thank
you,
you.
Adam.
Any other cases for either council?
For Council Lanessa Garcia, page 4, number 8.
Estate of Andres Segovia, cause number 2024 PB 489L2. Court marks Ms. Lanessa Garcia present in person. Mr. Juan Garcia, are you present?
His device is online, Your Honor. However, the client for Ms. Lanessa Garcia was the independent administrative name. No longer the client for Mr. Juan Jose Garcia.
Yes, Mr. Juan Garcia initiated these proceedings and then my client came in to Mr. Garcia's client acquiesced to my client requesting to be executor.
You filed for the enlargement of time. The court approved that yesterday.
Thank you.
June 9th at 9 a.m.
Perfect.
and it was already e-filed and e-served on council.
Thank you. And I did send Mr. Garcia some discovery, and that was the whole reason. Thank you.
All right. Any other cases for either counsel?
Not for Council Vanessa Garcia. Next in person is Council Ms.
great day.
Romero.
Thank you.
I'm sorry, page and case?
Page 9, number 20 for Council Romero.
San Juana de Leon Angiano versus Juan Jose Villarreal Jr., cause number 2024 CBI 1066C3. Court marks Mr. Romero present in person, Mr. Chu present by video conference. Good afternoon to both.
Good afternoon, Your Honor.
I think Mr. Chu may be frozen. He cannot hear us. Mr. Chu? He definitively cannot hear us. San Juana Angiano Juan Jose Villarreal Jr., are you present? Court finds parties not present. This is a jury selection conference, counsel?
Yes, Your Honor. Mr. Chu, well, we filed a joint motion for continuance, Your Honor. Mr. Chu advised me that his client's mother passed away this week. So in consideration of that, we've agreed to reset the current settings, Your Honor.
Good afternoon, Judge. Thank you, Mr. Romero. That is our agreement, and we had filed it with the court, Judge.
Very well taken. The court is signing off that that request for continuance. So I think rather than put more stuff on your plate, Mr. Chu, let me give you what the court would want in return as consideration if the court were in the same position. Let me just give you all just a docket control conference and just follow pretrial guideline order if and when, well, not if, when you're ready. Give us a docket control conference in 30 to 45 days, please.
Your Honor, may I reset this for a PTGO due?
That's exactly a docket control conference. Oh, I see, just by submission.
Correct.
Yes, the PTGO is due on or before.
March the 30th.
That's too soon. Give me the April setting.
That would be April the 27th by submission. And for your information, Your Honor, this case has not been subject to a mediation.
All right, so file the pretrial guideline order before April 27th. Mr. Chu, Mr. Romero, select a mediator, put that person's name in. If you can't, just leave it blank. I will fill one in for you. Any objections to the pretrial guideline order being scheduled and set for the due date, April 27th, Mr. Romero?
No, Your Honor.
Mr. Chu?
No objection, Judge.
All right, anything else on this case from either person?
We have nothing further. Thank you, Your Honor.
You have the court's sincere condolences, Mr. Chu.
Thank you, Judge. Bye-bye.
Have a good day.
Next case for Council Romero, page 9, number 21.
This is Mauro Usman Jr. versus Marta Dodier Blum Maria Elena Sanchez, cause number 2025 CVI 2647C3. Court marks Mr. Romero present in person, Mr. Tamez present by video conference, Mr. Garcia, Guillermo Garcia, are you present? Court finds Counsel Garcia not present. Good afternoon to both.
Good afternoon,
Your Honor.
Mauro Guzman, Marta Blum, Maria Sanchez. Any parties present? Court finds no parties present. Counsel, go ahead.
Your Honor, I think we've almost settled the case between my client, Mr. Tamez's client, and Mr. Garcia's client, but I believe that Mr. Tamez has filed a petition against now another party. I don't know if the deadline for that party has passed, Your Honor.
Good afternoon, Your Honor. Francisco Tamez for Ms. Marta Dodier Bloom. I did, in fact, file a third-party petition against Leoncio Signs, DBA Better Homes and Gardens Real Estate. I believe that Mr. Signs' answer date is this coming Monday, the 23rd. And so I would ask the court for purposes of today's hearing, if we can get that reset for maybe 30 days to give Mr. Signs at least up until Monday to file an answer, if not possibly file a default prior to the next setting.
Any objection?
No, Your Honor.
All right, this calendar call goes on to
How many days, Your Honor?
30 days after Monday. at least?
April 21st at 2 p.m.
All right, any objections to that, Mr. Romero?
No, Your Honor.
Mr. Tamez?
No, Your Honor.
Good luck to all.
Thank you, Your Honor.
Those are all the matters before the court for Council Romero and Council Tamez this
Have a
afternoon.
great day.
Have a good day, Your Honor. Thank you.
Thank you.
Next in person is Council Juan Hernandez, page 7, number 15.
This is American Express National Bank versus Cesar Cabello, also known as Cesar J. Cabello, cause number 2024 CBF 70L2. Good afternoon, Mr. Hernandez. Into the record, please.
Yes, I'm sorry.
Welcome to court. Court martial present in person. Are you Attorney Wells?
Yes, sir. William
Welcome
Wells,
to-
plaintiff, Your Honor.
Welcome to court, Mr. Wells. The court martial present. You're participating by video conference. Opposing counsel, Mr. Hernandez, is present in person. American Express National Bank, Cesar Cabello. Any parties present? Court finds no parties present. This is a third setting for bench trial. Counsel, what is the announcement?
Judge, plaintiff is ready to proceed.
All right. Mr. Hernandez?
I didn't hear.
Plaintiff is ready to go forward.
Well, be okay, but he's not here, Judge.
All right. Have you, Mr. Hernandez and Mr. Wells, had an opportunity to confer this afternoon?
No,
Not
Your
today,
Honor.
Judge.
I know that the last time we were here, the court ordered us to go to mediation. Plaintiffs refused to go to mediation, so here we are back again.
It wasn't just one time. It was twice. The court ordered
It's been-
for the parties to go to mediation in December, reordered mediation to mediate before March the 13th. Mr. Wells, Mr. Hernandez, have the parties mediated?
No, Your Honor. No.
No, sir, Judge, it hasn't mediated.
Why?
Well, Judge, I made inquiry into that today because I knew it was an issue, obviously. And the plaintiff has not refused to go to mediation. The costs were a major issue. Obviously, with a credit card account, there's some financial difficulties going on with everybody that ends up in a credit card case. And the mediation fee for the mediator that was proposed was $850 per party, is what I was told. So, you know, American Express is more than willing to go forward paying the $850 for a mediation on this, if that's what the defendant would like to do. But that fee is probably exceedingly difficult for the defendant to meet because we can't even work out a settlement agreement, which we've tried multiple times to do. And after the court initially ordered mediation, the plaintiff and defendant entered into some negotiation, and they were back and forth. And in January, the back and forth was not the last back and forth from American Express to the defense counsel. There wasn't any response from what I was told, and they couldn't meet the terms of American Express's settlement. So, you know, the
Are you
fee,
Cesar Cabello? I'm going to ask that you unmute your device.
Oh.
There's an unmute button at the bottom left of your screen. It's a red or microphone button. Press that button, please.
Okay, can you hear me now?
And yes, but now we can't see you. Turn on your video. All right. Are you Cesar Cabello?
Yes, sir, I am.
Welcome to court, Mr. Cabello. The court marks you present and participating by video conference. As you can see and hear from your device, your lawyer is present in person. Mr. Cabello, the plaintiff, the person that is suing you on behalf of American Express National Bank, their lawyer has indicated that they are ready to go forward with your case. There isn't an agreement, so this case will be heard and tried momentarily. Between now and that, this is the first contested matter on this docket this afternoon. So between now and then, keep in contact with your lawyer, and between now and then, your lawyer will be communicating with Mr. Wells. Mr. Cabello, do you have any questions for the court?
No, sir, I'll refer them to the attorney, please.
This is the first contested matter on this docket. Stand by, please.
Thank you.
Next case for Council Hernandez, page 8, number 18.
This is Robert William Slaughter versus Mexico Moving Company LLC, cause number 2023 CVI 1507C3. Court marks Ms. Soto present in person, Mr. Hernandez present by video conference. Mr. Green, are you present?
I am, Judge. I'm just making a quick appearance. I might stand by depending on how long it's going to take. The original individual that I represented, Judge, has been removed from the case. Plaintiff has subsequently filed an amended petition adding another defendant that I will probably be representing and subsequently filing an answer for. But I have not done that as of yet.
So you currently don't have a client present?
Presently, I do not, but there's one that's listed in the actual petition.
Have you filed an answer, response, or notice of appearance on behalf of that person?
I have not, Judge, but I have accepted service.
All right, so I mean, until you do that, you're just, I mean, unless you're making an appearance, are you making an appearance now?
Well, I wanted to make sure that we were actually clear with the court that I wasn't involved with this particular hearing, and I did want to kind of see how the proceedings went today, because apparently I'm going to be probably brought back in.
I guess what I need to know is whether you're in or not in, and if you're in, you can participate. If you're not in, you can't participate. I just need to know what your legal status is.
I would say at this particular point, I'm in for the new defendant, which would be National and International Movers, LLC.
All right, court marks Mr. Green present on behalf of that defendant or defendants. So noted. Are you, tell the court your name, please, into the microphone.
Ronald Ponton.
Mr. Ponton, tell the court the spelling of your surname, please.
Papa Oscar Nancy Tango Oscar Nancy.
Welcome to court, Mr. Ponton. The court marks you present in person. I say that so that we have a good and accurate record. And your lawyer is Mr. Hernandez?
Yes, sir.
All right. Is there any other person, lawyer or litigant present on this case?
Your Honor, my client should be on Zoom.
Mr. Slaughter, are you present?
Not present.
All right. The court marks no other persons present. Ms. Soto, Mr. Green, Mr. Hernandez, what is the announcement?
Your Honor, we're set today on Mr. Ponton's motion for summary judgment.
On behalf of what client?
On behalf of Mexican Moving Company, Judge.
Isn't that the one that was dismissed?
No,
This is the one that's coming in.
no. The one that was dismissed was Reina Madrigal individually. We brought in National and International Movers, which is her company.
Gotcha. All right, go ahead.
But Judge, you know, we're here, I think we're at the fifth amended original petitions and we don't mind, Judge, but I think that the motion for summary judgment is to tell the court that Mexican Moving Company is not part of the contract. Part of the person that is in the contract is Ms. Madrigal. Okay, so thereafter, I think that if we can get the summary judgment granted on the fact that Mr. Ponton and the Mexican Moving Companies are not liable under contract, now we can start working on the other agency.
The causes of action, the remaining causes of action. So Mr. Ponton has a motion for summary judgment.
That is correct.
That is set for today.
That is set for today.
All right, so
Now, what I would like, Judge, is I guess we could go over it unless we have an agreement that he is not liable under the contract. Then we can move on to the rest of the case.
But do you know the answer to that?
Come again?
Do you know the answer to that?
No.
We should talk before. Is there an agreement as to that issue?
So Your Honor, that had not been brought up, but I can certainly confer with Mr. Hernandez on the point only as to removing the contract allegation against Mexican Moving Company.
Yeah.
Yeah, so talk to each other. I mean, if you can narrow down the causes of action and leave the strongest ones outstanding, I mean, you could agree to that or you may not agree. I don't know.
Well, I understand, Judge, but the other thing is, you know, I would like maybe to have a pretrial guideline order so that we have a deadline and let's not amend stuff. I still have some discovery that is.
Okay, full stop. Full stop. Unless the court hears a good reason basis to continue this case, unless it's in writing filed by, with an affidavit, there's no more, is there? Yes, the clerk's office, is there a motion for continuance?
No, Your Honor.
So there is no need for any other settings. You're set for final hearing and motions for summary judgment. Why would you need more? I mean,
Well, Your Honor, that's the thing. I did file another motion and if the court requires a written motion, I can do that. But this is part of the issue. I know that they're stating that I just submitted my pleadings. But I was not aware, the whole issue here is that Mr. Ponton is, on behalf of Mexican Moving Company, is claiming that he had no involvement. When I sent written discovery to Mexican Moving Company, they're stating we have no emails, we have no payments received. I sued Reina Madrigal individually. She provides through informal discovery receipts of payment to Mexican Moving Company. My client sends a payment on one day, very next day, National and International Mover sends that payment over to Mexican Moving Company. So there have been some discovery issues that required me to do the fifth amended petition to get the proper parties before the court. There is one party that is still outstanding, have no idea who that third party is, and I don't want to bring that in because I don't think that they have any locating information or name from any of the defendants right now as to who that other company might be. So I will need another setting, Your Honor, just so that we can address the incomplete discovery that was provided to me by Mexico Moving Company.
And Your Honor,
and that's Mr. Hernandez's client?
Correct.
If we need to correct it, we will correct it, Judge. It's just a matter of, I know that the motion for summary judgment could have and should have been heard a long time ago. It wasn't, and I'm not complaining. I just want to be able to say, okay, these are the up-to-date pleadings. Are we good? Yes, we're good. Well, 3-4 days later, I don't want another amendment. It's over and it's done with. Now, we also know that Ms. Madrigal came in maybe about a month ago, maybe. And then there's also another defendant. You know, they might affect our case. And I want to make sure that if they're going to come in, then fine, they're going to have a certain deadline. And if they don't have that deadline, then I guess we all gang up on them. I don't know. But to me, that's the issue, Judge. I mean, I want to make sure that Mexican Moving Company is not a part of damages that are going to be flowing out of the breach of the contract. Now, if in fact the Ms. Madrigal paid or gave a referral fee to Mexican Moving Company, well, then I can also understand those things. And I think even the court needs to know those things as well. We need to know those things. But, and I know we don't have a motion for continuance, but to me, Judge, I think if you try the case today, it still leaves maybe 2 other parties, defendants.
So I guess let me ask you, and I did this with the case earlier with Mr. Romero and Ms. Garcia, but let me ask you the same question, Mr. Hernandez, without affirming whether the allegations as made here today by Ms. Soto are true or not. Factually, all of the procedural history that she is saying, is that true and correct?
I don't know what procedural history you're talking about, Judge.
The outstanding discovery, the addition of another party, the summary judgments that have been filed, all of the things necessary for this court to make a finding that this case is in fact complex.
Yeah, Judge. I mean, the petitions were filed on September 18, 2023. We have been doing a lot of work on it, and we've been receiving discovery. I think we send them discovery. They responded to the discovery. But then we've had amended petitions, amended motions, and the discovery in and of themselves, I think they're pretty much outdated. But I don't have a way to look at it and say, okay, today is the last day. If we're going to do the discovery corrections and all of that, we need to do it by a certain date, and that's it. And to me, I think that would make the case go a lot faster. I think it would make the case go a lot smoother. And everybody is going to be able to tell the court what it is. And we have to file a motion for summary judgment. We'll do a motion for summary judgment. They'll do a response, or they'll give us a motion for summary judgment. But we take care of the issues and of the petitions and of the discovery that needs to be taken care of.
Response.
So that's the thing, Your Honor. So I don't think the discovery is outdated. I think it's incomplete, because if you're telling me that there's no payments received, there's no emails, and then a third party is telling me, here's a copy of all the emails, here's a copy of the payments sent, and the communications between the co-defendants, then it's not outdated, it's incomplete. And I was not aware of that until I found that other company that I have now brought in. And we found that out with Judge Hale. He allowed us some discovery discussions at mediation, and he brought that to light to me through the new co-defendant.
We've not had an opportunity to discover anything from Ms. Madrigal as well, Judge. I mean,
Ms. Madrigal is the recently added litigant?
She's recently removed, and we brought in her company, National and International Movement.
I see. So anything to add before I opine or make decisions, Mr. Green?
Well, Judge, it kind of puts me in a different situation. When I first represented Ms. Madrigal, I filed a Rule 91 just based on the improper party being sued. And so plaintiff's counsel subsequently obviously amended her petition taking her out. Now she has added another defendant, her company. So it does put me in a different position to where representing that particular company, if that's a proper party, which I'm taking the position that it would be, well, then I think I should be entitled to some leeway with the court to conduct maybe some limited discovery to make sure that I get my hands around this case before having a final hearing. It just kind of puts me in a different position now that I'm dealing with a real party to the suit.
So let me do this, and then I'll hear from each of you and see if you have any responses or objections. In cause number 2023 CBI 1507C3, the court finds that this case should be and is hereby certified as complex because of the parties, the currently existing parties, the recently dismissed parties, and the recently added parties, because of the discovery, the nature of the discovery, the outstanding discovery, the allegations made between the parties, and because of the international considerations and contemplations of this case. For those reasons, this case is certified as complex. These are orders that are due to the court honor before
March 30th.
That'll be by submission. Let me also make that a deadline for all lawyers and parties to file. I was going to give you an orders due date for pretrial guideline order, but I can't do that unless we know whether the recently served defendant have all defendants made an appearance.
One, Your Honor, was served Transportes Point, and I may just do a default judgment on that because they never made a written appearance, but the return of service has been on file for that remaining defendant.
Everyone else has been served and been given an opportunity thus far to appear.
Correct.
All right, so then I'm going to give you that same deadline for a pre-trial guideline order. I think Ms. Soto and Mr. Hernandez's argument is well taken. You should have a structured, definitive series of deadlines so that you can finish all of these things. But if I do this, and I usually do this in court, but I think you all need to sit down with a calendar and because there's more than one party, more than one defendant, more than two parties, more than two defendants, more than two lawyers. I think because of all of those, and I've just certified this case is complex. So sit down with each other with a calendar, with a pretrial guideline order, fill it out, including a mediation date with a person, and submit that to the court on or before March the 30th. If in the very unlikely event, and I really discourage this, but if in the very unlikely event that you can't agree to any dates, then just file some competing pretrial guideline order dates with a brief statement as to what the disagreement is with dates, and I'll sign one or the other. Thoughts, comments, or objections, Mr. Green?
No, no objections, Judge. Thank you so much.
Thoughts, comments, or objections, Ms. Soto?
No objections, Your Honor.
Mr. Hernandez?
We have none, Judge.
Anything to add or any questions, Mr. Ponton?
I just want to thank this court. I just want to thank this court for the 1,584 miles I have to drive every time I have to come deal with this. I really appreciate that, sir.
You're welcome. Have a good day.
Your Honor, if I may, there is no order to dismiss as to Reina Madrigal Martinez, so we cannot remove her from the parties.
So remove it from the pleading, but if the court wants a notice of nonsense, I can prepare that this afternoon.
All right, file it before March the 30th.
All right.
All right, talk to your client, Mr. Hernandez.
Yes.
Have a good day.
Thank you, Judge.
Mr. Hernandez has an item for page 4, number 9.
To the estate of Jason Ramirez, cause number 2025 PB4 21L2. Court marks Mr. Hernandez present in person. Mr. Martinez King, are you still present?
Device present in the virtual room.
Any parties present, Lauro Ramirez or any other person, any persons present on the case of Jason Ramirez? This case is set for dismissal.
Pending, Your Honor, is the application to determine heirship, citation by posting and publication to disinterested witnesses, proposed oath and order, the waiver, and a proof of death. Mr. Juan Hernandez did his due diligence and filed his report for attorney ad litem on the application for letters of administration.
Mr. Martinez King, is this case isn't ready to go forward and it's set for dismissal. What say you?
So we did have some delays with the Lauro Ramirez in regards to him getting the attorney ad litem fees and such. And so for the most part, I think we will be ready to if we can get a setting within 45 days, it should be good to go. Everything else has for the most part been completed.
So what the court is inclined to do, if not dismissal, Mr. King, is just set this case to inactive and just fill out the court's form and request a setting when this case is ready. I can give you 45 days, but you might need 47. I can give you 6 months, you might need 8 months. So I'd rather just give you the time you need by setting this case to inactive, and you tell us when this case is ready.
I understand, Judge.
All right, any objection, Mr. Hernandez?
No objection, Judge.
Mr. King told the court, Mr. Hernandez, that you had already prepared a report.
I have prepared a report and I've submitted the report, Judge.
Well, let me ask you this, Mr. Hernandez. I mean, this case isn't ready and you filed a report. Is there anything you want to tell the court with regard to fees?
No, Your Honor. In fact, we've talked to Mr. King's client, and she knows what she has to pay, Judge. The only thing I can say, I can ask Mr. King to kind of encourage her to come in and take care of the attorney's fees.
Okay, well, if it becomes an issue, then file something with the court. I don't expect anyone to work for free and especially complete their work for free. So just file something with the court should it become necessary.
Yes, sir.
All right, good luck to all.
Those are all the
Thanks,
matters.
Judge.
Counsel Martinez King and Counsel Hernandez is on recall.
All right, have a great day, Mr. King.
Next,
Likewise.
then Counsel Lisa Mar Soto, page 3, number 6.
The estate of Armandina de los Santos, cause number 2023 PB 4108L2. Court marks Ms. Soto present in person. Mr. Garcia Dávalos is also present in person. Good afternoon to both.
Good afternoon.
Fernando Martinez, Elena Mike, where are you present?
Fernando Martinez present, sir.
Mr. Martinez, welcome to court. The court marks you present in person. As you can see and hear from your device, your lawyer is present in person. Elena, help me pronounce your client's surname. Mike, Elena Mike, are you present?
She won't be on my client's in an assisted living facility, so she's not able to log on.
Court marks Mr. Dávalos, Ms. Soto, and Mr. Martinez present. Counsel, what is the announcement?
Your Honor, I had filed a motion for an accounting. The court set up for hearing today. Mr. Garcia Dávalos did file an accounting court. If I may just have a couple of minutes to confer with him, I was conferring on the item case earlier regarding that motion.
Any objection?
No objection, Your Honor.
This is the second contested matter without knowing anything else.
Yes.
Good luck.
Thank you,
Yeah,
Judge.
thank you, Your Honor.
For Council Garcia, page 4, number 7.
This is in the matter of Heriberto Delgado Reynoso, cause number 2024 CIG 17L2. Court marks Mr. Garcia Davalos present in person. Are you Vanessa Ann Vela? Welcome to court, Ms. Vela. The court marks you present in person. Mr. Davalos?
Yes, Your Honor, we are set for a status. I believe the last time we're at the point in which we're trying to get for Mr. Reynoso, I guess, an active or what is it, resident alien card.
Right.
And I believe Ms. Vela represents the hospital. And so I obtained some information from their attorney, and I was able to as well get a colleague, Mr. Bali, to help me out with the application. So basically I need to complete that application and resubmit it because they tried to submit it and it got denied, or it just simply they didn't give any answer or response from the UCIS, which is the department that is in charge of reviewing the applications. There's really not that much information that we have from Mr. Reynoso, so that we'll be able to very likely get a permanent resident card. I spoke with a hospital representative and they don't have any identification of cards or anything like that. And so that's something that would help in submitting the application. And so we're just simply going off on the limited information that is available. Obviously, one of the things is that when I submit the application, like if I were to submit the application, then I'm not his attorney, I'm his ad litem, cardinal item. And so I guess I can double check to see whether I will be allowed to file that application, or if I file it, whether.
This is the application for.
So that he can get a permanent resident card. And
I thought that was Mr. Bali's role.
Yeah, I spoke with him and I sort of like, and he's not appointed or designated by the court. It's more like sort of like doing it on his, trying to assisting me to help me out on it.
But has he gotten paid?
No, he's not getting paid.
But you filed a motion requesting
Money.
payment on September 16th and the court signed an order in October. Has Webb County paid that?
No, I haven't gotten any monies from the county or anything like that. That's monies in case they were needed to pay for the application.
Oh, I see.
Yeah, no, I mean, and I don't.
Understood.
Yeah, so it's mainly Mr. Valley, like sort of like helping me out. And so I sent them a draft that was sent from their counsel. And so I just need to basically see what can be done to file it. I don't know how long it's gonna take, whether UCIS is gonna be able to process it and accept it. So maybe in a couple months, I'll go ahead and file it, and I'll give the hospital, I guess, a status in it. Once it gets filed.
All right, so I have two questions. That was the first question. So first question, you think that 2 months would be reasonable, necessary, and sufficient to apprise the court of what the status is?
I guess the only thing that I'm gonna apprise the court is whether it got filed, and if it got filed, then hopefully maybe they denied it, maybe they accepted it, but I don't really know what that department is in terms of being able to process it.
Sure. All right, give us a setting in 2 months, please. 60 to 75 days.
June 9th at 9 a.m.
And the second question, and either one of you can answer, Mr. Garcia, or Ms. Vela. So the reason and the purpose of guardianships is so the court can ascertain the well-being of persons that are unable to care for themselves. What is the status of Mr. Reynoso? Is he well, not well? How is he doing?
At the hospital, Laredo Medical Centers for 711 days. So he's been admitted since
April the 4th of 2024. He's been medically cleared since the 5th of April 2024. He is not able to be discharged because he is completely bedbound and is demented. So the hospital has been caring for him. In September of 2025, the hospital hired an attorney, Whitaker and Bell. They submitted the application. The application was denied in October, but we were not made aware until maybe February, I believe, or January, that we were able to get some sort of response through the USCIS. So he remains in our care. Health and Human Services is willing to accept the patient and take guardianship. Because I went the way of Social Security, I went on behalf of the patient. I requested, to see if he was able to be funded. So he is. He did work the 40 quarters. But Health and Human Services will not, Social Security will not release the funds that is due to the patient unless he has an active residency card, which is not active.
So Garcia, let me ask you this, because maybe we're putting the cart before the horse. And I know, like, once more, the purpose of the guardianships is so the court can ascertain and make and ensure that the persons that are unable to care for themselves are well, their person and their estate. In this situation, since this is a court-initiated guardianship, although I guess that's a misnomer because it was the hospital's attorneys that initiated the guardianship. Your efforts have been to see if Mr. Reynoso can be taken care of by Health and Human Services. And all of the efforts thus far have been for his well-being through Health and Human Services. But what about the guardianship itself? I mean, I don't think anybody would dispute that it's needed, right?
Well, Your Honor, the order says that I'm supposed to investigate to see whether the guardianship is needed. And so I
Right.
did. And then I took a step further and
Sure.
I filed and I was able to, we were able to find a way to make HHS or whatever.
Sure.
For them to actually respond to us to say, yes, we actually do.
Because where I'm going with this, if you in your professional judgment do feel or assess that a guardianship is in fact needed, you can move on the guardianship and you basically pass the baton on to the person that would be appointed guardian of his person and his estate. In other words, you're going to find yourself in that role until you prove it up. You see what I'm saying? So if you prove up the guardianship, the court appoints a guardian, and that guardian now fills in your role and would be in charge of making all the applications to HS, making sure that monies are paid or not paid or whatever is older, whatever the case is, but that would fulfill your obligation. You pass on the baton to a court-appointed guardian.
Yes. And so that's what I mean, we're almost there.
Sure.
I was almost,
Sure.
done with this case.
And we got
And so-
sidetracked. Yeah.
And so the only reason why I was not able to be done with this case is because the Health and Human Services said we cannot come in as a guardian because he doesn't have an active permanent resident card. And that's the only reason, and that's where everything just simply stopped. And I did make.
So as long as he has status, there is some reassurance that they will step in as guardian?
The contact that I made with them. So after the guardianship was filed, Health and Human Services reached out to me directly to the hospital. I set up the interview. They came and interviewed him twice already. And with the first interview, they requested to see if he was funded. So I went the route. I went to Social Security, did all that. Confirmed with them that he is funded with the 40 quarters. He does qualify for the retirement. Then they came again for the second time, spoke to the patient, agreed that they could accept him, but unfortunately without his residency card, those funds would not be released from Social Security. And that's where we submitted the application for his residency card to be renewed.
Understood and very well taken. All right. Well, let's see if we can get some traction between now and June the 9th.
Yes. Hopefully, and that's pretty much it. I mean, that we can do. I mean.
No, I understand and agree with you. Thank you for all of your service and work both. I'll call this case on June the 9th. Anything else on this case?
No, yeah.
Any other cases for Mr. Garcia Davalos?
Just the one on Rico.
Understood.
Thank
Thank you.
Next in person, Council Maricela Rangel, page 3, number 5.
So the estate of Benita Sanchez, cause number 2022 PB 47202, court marks Ms. Maricela Rangel present in person. Silverio, good afternoon. Silverio Martinez, Maria Guadalupe Macias, any other persons present?
Good afternoon, Your Honor. Silverio Martinez for the movement in this case, in this hearing.
Court martial president participating by video conference. Please step forward if you are present on this case.
My client, Ms. Magana, the independent executrix, is here. Apologize for my voice, Your Honor. A little bit of.
No worries. Find a microphone, Ms. Magana. Speak into the microphone and to the court. Are you Benita Magana?
Yes.
Welcome to court, Ms. Magana. Court martial president in person. The person on your left is your lawyer. Are you Maria Guadalupe Macias?
Yes.
Welcome to court, Ms. Macias, court martial president in person. As you can see from this device, your lawyer is present and participating by video conference. We're set for a final hearing. Counsel, what is the announcement?
Your Honor, it's we're ready to proceed on our motion to remove independent executor.
Announcement, Ms. Rangel?
Obviously, Your Honor, we did file a response and also a further reply with some information. Obviously disagree with the motion for removal of the independent executrix.
All right.
Correct,
Mr.
Your Honor.
Martinez,
We filed, I'm sorry, Judge.
have you had an opportunity to confer this afternoon or this morning?
No, Your Honor.
We have on several occasions, Your Honor, and have not been able to reach an agreement. We filed a motion, they filed a response, we filed a reply, so we've been going back and forth. I think the court's been able to look at them.
I have not discussed this matter with Mr. Martinez other than through the filings of the pleadings, Your Honor.
All right, this is the third contested matter set for this afternoon. So talk to each other between now and then, and we will proceed shortly.
I will do my best, Your Honor. I'll try to see if I can reach Mr. Martinez by
Mr.
phone.
Martinez, make yourself available for Ms. Rangel, and I'll call this case shortly.
And by the way, Judge, I don't expect this to go past, Ms. Rangel, correct me if I'm wrong, but I think 15, 20 minutes at most.
I suspect so, Your Honor. I like I said, I disagree with the motion, so I
All right. Yeah.
suspect so. I don't know.
It's a real simple issue.
All right, talk to each other. Good luck to both. Stand by.
Thank you, Your Honor.
First online, Council Clarissa Canales, page 6, number 12.
The estate of Isabel Palasios, cause number 2025 PB 760L2. Good afternoon, Ms. Canales.
Good afternoon, Judge.
Court martial present, you're participating by video conference. Eduardo Palasios, are you present? Step forward. Court marks Mr. Palasios present but not present. Ms. Canales?
Yes, Your Honor. Oh, did you say he's not present? 'Cause
I
believe
think he may have stepped out to use the facility. So he's here. He's just.
Yes.
Are you Mr. Palasios? Step forward. Speak into the microphone and tell the court, are you Eduardo Palasios?
Yes, sir. I'm Eduardo Palacios.
Welcome to court, Mr. Palasios. Court marks you present in person. As you can see from this device, your lawyer is present by video conference. I'm going to ask that you unmute your device, Ms. Santos, and tell the court, are you Olga Santos?
Yes.
Are you making an appearance in this case?
No, I'm just going to listen to the outcome of the court or the hearing.
Are you a party to this case?
I'm the sister to Mr. Palasios.
Yes, sir.
So, okay, understood.
Yeah, I'm just going to listen to whatever happens in court today.
All right, I'm gonna mute your device and I'm gonna unspotlight your video. Is there any person here that's another person here that's making an appearance? Please step forward. Jose, Yolanda, Jacqueline, and Jose, step forward. Are you, tell the court your name, please.
Josefa Palacios.
Okay. Yolanda Zuniga. Jacqueline Rodriguez.
Welcome to court, Ms. Zuniga, the court marks you present in person. Tell the court your name, please.
Jacqueline Rodriguez.
Welcome to court, Ms. Rodriguez, court marks you present in person. And tell the court your name, please.
Josefa Piña,
Ms. Zuniga, what is your relationship to Isabel Palacios?
My mom,
And what is your relationship to Ms. Palacios, Ms. Rodriguez? And your relationship to Ms. Palacios, Ms. Peña? All right, understood. Welcome to court to all. Ms. Canales, what is the announcement?
Yes, Your Honor, we're ready to proceed on the application to probate the will and for letters of testamentary.
All right, who is your, which persons or what person will we be calling to testify?
The applicant, Your Honor, Eduardo Palacios.
You're not calling Ms. Zuniga, Ms. Rodriguez, or Ms. Peña?
No, Your Honor.
All right, Mr. Palacios, would you step in front of the, directly in front of the microphone, raise your right hand? Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes, Your Honor.
All right, you may lower your hand. Ms. Canales, go ahead.
Yes, can you please state your name for the record?
Eduardo Palacio.
Mr. Palacios, you have filed an application to probate the will of Isabel R. Palacios, is that correct?
Yes.
And where do you reside?
Laredo 1719 Lomas del Sur.
Okay, and is that in Laredo, Texas?
Yes.
And the decedent, Isabel R. Palacios, is your mother, is that correct?
Yes.
And she died on June 6, 2025, is that correct?
That's correct.
In Laredo, Webb County, Texas, at the age of 99 years old, is that correct?
That's correct.
And at the time of her death, she was residing in Laredo, Webb County, Texas?
Yes.
Now she owned some property, generally described as real estate, cash, personal effects, and household goods at the time of her death in excess of around $200,000. Is that correct?
Yes.
And at the time of her death, she left a valid will dated November 12th, 2024, which was never revoked. Is that correct?
That's correct.
And 4 years have not elapsed since the date of her death, correct?
That's correct.
And after the date of the will, there was no child that was born or adopted by your mother, correct?
That's correct.
And no marriage of the decedent was ever dissolved after the date the will was made?
No.
And the will named you to serve as independent executor?
Yes.
And no state, government agency of the state, or charitable organization was named by the will as a devicee, correct?
That's correct.
Okay. And you're asking the court to admit this will for probate?
That's correct.
And you're asking that letters of testamentary be issued to
That's
you?
correct. That's correct.
Now, there was a property that was under contract to sale that decedent had signed prior to her death?
That's correct.
Okay. Judge, that's all I have. The will has been filed and citations were issued and returned, and we're just asking the court to grant letters testamentary to my client, Mr. Palasios, so that he can go ahead and transfer any property or anything under the will that's pending.
Ms. Santos, Ms. Zuniga, Ms. Rodriguez, and Ms. Peña, the court has heard from your brother, Mr. Palacios. Does any other person want to be heard on this matter? Is there anything you want to tell the court? All right. Folks, in the case of your mother, cause number 2025 PB 760L2, the court hereby finds that it has jurisdiction over this case, meaning this is the proper court form and venue to consider this this case. The court finds that your mother resided in Laredo and Webb County. The court finds that she unfortunately passed away on the 6th day of June 2025 at the age of 99. The court finds that she left a valid executed will that was never changed, revoked, or modified. That was dated November 12, 2024. The court finds that no children were born or adopted of her after the execution of the will. Neither was any marriage dissolved. The court finds that she does own property in Webb County. The court finds that there is a necessity to administer her estate. The court finds that Mr. Palasios is qualified and is not disqualified from serving. The court finds that the court should appoint him as the executor of your mother's estate. For all of these reasons, the court grants the request, admits your mother's will into probate, and will cause letters of testamentary to be issued out to Mr. Palasios. Ms. Canales, the question the court has is, what amount do you believe? Oh, and the court hereby takes judicial notice of the entire case file, which includes Ms. Palasios' original will, original death certificate, the citation by posting, and all of the case file. Ms. Canales, what amount do you believe would be reasonable and necessary for the court to set as a bond in this case?
Your Honor, she does have two properties, I believe one in Laredo and one in Bexar County. I'm not sure the total value of that property. Maybe Mr. Palasios could give the court some information on that, and then we can proceed from there.
Mr. Palasios, what is the value of property of your mother's estate?
I don't have a number, Your Honor. I know the one in San Antonio is about 250,000, but the one here, I have no number for that.
Based on that information, Ms. Canales, what is your request?
Your Honor, I'm not sure. I think I'm going to leave it up to the court, and see what the court would recommend. I don't know if the court would be willing to waive a bond.
What does the will say?
The will, let me see. You pull it up. It says that it shall not be required to furnish any bond of any kind. So it's asking for no bond.
Okay, page and clause?
Excuse me?
The page and clause number?
Yes, Judge, hold on. Oh, I just closed it. Okay. It is page 2, section 5, C.
It is my will and desire that I hereby direct that in the administration of my estate, my independent executor or any successor shall not be required to furnish any bond of any kind. There it is. I see it. All right, well taken.
Thank you, Judge.
Okay.
Court is filling in the blank and setting the bond at 0 per the will. The court has approved the request, signed the order filed by Ms. Canales. The inventory on this case is due honor before
June 30th at 2 p.m.
Have anything else on this case, Ms. Canales?
No, that's all I have, Your Honor.
Have any questions for the court, Mr. Palacios?
No, Your Honor, thank you.
Ms. Zuniga? Ms. Rodriguez? Any questions? Ms. Peña? And Ms. Santos? All right, you have the court's condolences. God bless you and your family. Have a good day.
Thank you, Your Honor. May I be excused?
Yes, have a good day.
You too. Thank you.
Next online is Counsel William Morris, page 7, number 16.
This is Brogo Transport LLC versus Interfleet Brokerage, cause number 2025 CVD 44L2. Good afternoon, Mr. Morris.
Good afternoon, Your Honor.
Court marks you present and participating by video conference. Good afternoon, Mr. Barrera.
Judge.
Good, court marks you present and participating by video conference. Any parties present? Court finds that no other persons are present on this case. Counsel, this is a final hearing. What is the announcement?
Your Honor, we are ready to proceed. It's also a hearing for a motion for a summary judgment.
Announcement is ready. What is your announcement, Mr. Barrera?
Ready, Judge.
So there is no agreement. Have you all spoken today on this hearing and the summary judgment?
We spoke briefly.
Yeah.
I think 2 days ago, Judge. Or, yeah, a couple days ago.
All right, if this is a contested hearing, this is the 4th contested matter on the court's docket today. Between now and then, see if you can narrow down the issues, and I'll call this case momentarily.
Thank you, Judge.
Thank you, Your Honor.
Next online is Counsel Guadalupe Castillo, page 5, number 10.
This is the estate of Oscar Escamia, cause number 2025 PB518L2. Good afternoon, Mr. Castillo.
Good afternoon, Judge.
Court marks you present and participating by video conference. Ms. Canales, are you still present?
No, Your Honor, she was in ad litem, but the independent administrator was back on.
Appointed. This is set for inventory. You're absolutely right. Mr. Castillo, what is the announcement?
The announcement, Judge, is that we have filed an affidavit in lieu of inventory, appraisement, and list of claims as permitted by Texas law. My client, Cristina Escamia, who is the independent administrator, is the sole heir and only heir of the decedent. And so she has reviewed all the debts, all the inventory, and has filed her affidavit in lieu of.
Court has received, reviewed, and considered that well taken and approved. That brings this case to a close. Anything else on this case, Mr. Castillo?
No, Judge, that's it. I don't have any other cases.
It's good to see you. Have a great day.
You too, Judge. Thank you.
Next online is Counsel Armando Echeverria, page 6, number 13.
This is the estate of Ernestina Flores Villarreal, cause number 2025 PB959L2. Good afternoon, Mr. Echeverria.
Good afternoon, Your Honor. Armando Echeverria here representing Magda Elsa Villarreal in the estate of Ernestina F. Villarreal, Your Honor.
Ms. Villarreal de Gutierrez, I'm going to ask that you unmute your device.
Got it. Thank you.
Are you Magda Elsa Villarreal de Gutierrez?
Yes, I am.
Court marks you present and participating by video conference. As you can see and hear from your device, your lawyer is also present and participating by video conference. Are you Jesus Villarreal? Mr. Chavarria, do you know if this person...
I think he's Miss Villarreal's brother.
There you go. I'm on.
Are you Jesus Villarreal?
Yes, I am.
Court martial present and participating by video conference. What is your relationship to Ernestina Flores Villarreal?
Jesus Villarreal, I am her son.
Court martial present. Are there any other parties present on this case? All right, Mr.
No.
Echevarria, what is the announcement?
Yes, Your Honor, this is an application to probate a will as a muniment of title. I brought Ms. Magda Villarreal to testify.
Ms. Villarreal, would you raise your right hand, please?
Yes.
Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes.
You may lower your hand. Mr. Echevarria, go ahead.
Thank you. Ms. Villarreal, can you please state your name for the record?
Magda Elsa Villarreal de Gutierrez.
And what was your relationship to the decedent?
I was her oldest child, her daughter.
Okay. Your mother passed away March 30th, 2024. Is that correct?
Yes, she did.
She passed away in Sabinas Hidalgo, Nuevo León, Mexico, correct?
Yes.
Okay. Now, this court has jurisdiction over this matter, and venue is proper because your mother resided in this county and had a domicile or fixed place of residence here in Texas. Is that correct?
Yes.
Now, your mother owned real and personal property with an aggregate probable value of at least $100,000. Is that correct?
Yes.
And your mother did not receive Medicaid benefits on or after March 1st, 2005. Is that correct?
No, she did not.
Now, your mother executed a valid written will dated November 6, 2014, which was never revoked, correct?
Yes.
Now, the subscribing witnesses to your mother's will are Arturo M. Campos and Jose Luis Villarreal. Is that correct?
Yes.
And your mother's will named you, Magda Elsa Villarreal de Gutierrez, to serve as executor without bond or security. Is that correct?
Yes, she did.
Now, no children were born or adopted by your mother after the execution of this will?
No.
And your mother's estate does not owe any unpaid debts other than a debt secured by a lien on real estate? Correct?
No.
No.
She.
Correct.
Correct.
Okay. And for that reason, there's no necessity for the administration of the estate, correct?
Right.
Now, no marriages of your mother were ever dissolved. Is that correct?
I'm sorry, say that again?
No marriages of your mother were ever dissolved. Is that correct?
Correct.
Now, your mother's will does not name the state of Texas or an agency of the state or a charitable organization as a DYC. Is that correct?
Correct.
And 4 years have not elapsed since the date of your mother's passing and before this application, correct?
Correct.
Your Honor, we ask the court to take judicial notice of the entire case file and admit this will as a muniment of title.
Any other witnesses?
That's it, Your Honor.
Ms. Villarreal de Gutierrez and Mr. Villarreal, in your mother's case, cause number 2025 PB 959L2, the court takes judicial notice of the entire case file, which includes the application filed by Ms. Villarreal de Gutierrez, the citation by posting, the citation by publication. The court finds that Ms. Villarreal passed away on the 30th day of March 2024, having led a valid executed will. The court finds that all of the requirements have been met under Texas law and the Texas State's Code to grant the request. The court hereby admits Ms. Villarreal's will into probate as muniment of title. These are the orders of the court, and the orders are due to the court honor before
March 30th by submission. Also for the oath, Your Honor, and proof of death, executed proof of death.
those are the orders due. All of those are due honor before that date. Ms. Villarreal, do you have any questions for the court?
No, no questions, Your Honor.
Mr. Villarreal, do you have any questions?
Your Honor, the order admitting will to probate is here.
Ah, I missed it.
And you did not mention Oh, my apologies.
The order granting the request and admitting Ms. Villarreal's will into probate as muniment of title, the court has now received, reviewed, and considered. It is in due form. The court has signed off on it. Thank you for doing that before this hearing, Mr. Chavarria.
The only
Thank
thing
you.
pending would be the oath, the executed oath for March 30th.
All right.
I will have that filed today or tomorrow, Luis.
For the record, the judge has no relationship to and has never seen or heard of these other Mr. and Mrs. Villarreal. So, Ms. Villarreal, Mr. Villarreal, the court wishes you well, and you have the court's condolences. Have a good day.
Thank you very much,
Thank you
Judge.
very much, Donna.
Any other cases for Mr. Echavarria or Mr. Dickerson?
No, Your Honor.
All right, good to see you, counsel. Have a great day.
Thank you. May I be excused, Your Honor?
Thank you.
Yes, sir.
Thank
Court will
you, Your
stand-
Honor.
Yes, have a good day. Court will stand at ease momentarily. Good afternoon. We are on the record once more. This is the family civil guardianship dockets for Tuesday, March 17, 2026. The time is now 4:02. Court is once more in session. Ms. Rodriguez.
Next online is counsel Edward Gendry. I'm assuming they're here for page 8, number 17.
Are you here for Biones versus Lopez?
Yes, Your Honor, John Duff on behalf of plaintiff.
This is Fermin Briones, Luciano Lopez, Tradex Logistics LLC, 2025 CVM 95L2. Mr. Gendries, what person are you here for?
For Tradex Logistics and Luciano Lopez.
Court marks you present participating by video conference. And Mr. Duff, what litigant are you here for?
Plaintiff, Your Honor.
Court welcomes you both, counsel. Any other person here on this case? All right, court marks both counsel present. This is a docket control conference. There was a Rule 11 agreement that was reviewed for the court by the court. The court wrote in, approved, and ordered it, signed it, I think yesterday. Today's Tuesday, would have been yesterday.
Yes, sir.
So, but we're here for a docket control conference. Counsel, do you all have a pretrial guideline order?
No, Your Honor. I think if we have a trial date, we can, the court can draft it, or we can draft.
Let me ask you this, Mr. Duff, you're here on behalf of the plaintiff. Are you asking for a bench trial or a jury trial?
Jury trial, Your Honor.
How much time would you need? 3 months, 6 months, 8 months?
Let's call it 8.
Any objection to the court setting this in November, Mr. Gendries?
No, Your Honor.
Ms. Rodriguez, what jury trial date, if any, do we have in October, November, December?
It would be October.
All right. So this would be the voir dire date on October 16th at 8 a.m. and your trial date, which is your opening statements, on October 19th at 8 a.m. Let me give you an orders due date, and that's an orders due for your pretrial guideline order. Your pretrial guideline order is due on or before?
Is March 30th too soon, Your Honor?
Counsel?
That should work, Your Honor.
I agree.
All right, just file it in on or before March the 30th. So, in case you are not familiar with this court, you'll begin voir dire on a Friday at 8 a.m. and we'll go until necessary, but usually you should be able to wrap up before lunch. We'll release the veneer persons that are selected and not selected, I guess, before lunch. That gives you all weekend to continue talking or preparing as the case is. And then at 8 a.m. or shortly thereafter, as soon as the jurors are done having breakfast, you'll go straight into your opening statements. Thoughts, questions, comments, or concerns, Mr. Duff?
Nothing from plaintiff, Your Honor.
Mr. Gendries?
No, Your Honor.
All right, the court wishes both of you well. Thank you both.
Thank you, Your Honor. May I be excused?
Yes.
Thank you.
Page 1, number 1.
In the matter of Roberto Palasios, cause number 2001, PB 652L2. Olivero Canales, are you present?
Not present or identified in the courtroom, Your Honor. Mr. Eduardo Palasios just coincidentally was here in the courtroom on a previous matter. Our probate court investigator did speak to him.
Yes, Your Honor, that is correct. I did release him, Your Honor. I provided him in a final annual report and annual final annual account. I have his email. I'll try to reach out to him to set a date when he's gonna bring them, but he has my contact information, Your Honor.
Fantastic. Give us one more setting then.
Your Honor, may we set it for the South Rep?
Yes.
It would be April 17th at 2 p.m.
So ordered, well taken. The court finds that there was good cause, reason, and basis based on the report of our probate court investigator on the record to not dismiss this case. This case is set for final accounting April 17th at 2 p.m.
Page one, number 2.
In the matter of Ricardo Ruiz, cause number 2010, PB 633L2, Olivero Canales, are you present?
Not present.
Luis Ruiz, are you present? This is a show cause hearing. The court finds that there is no good cause, reason, or basis. To keep this case on the docket, this case is dismissed for want of prosecution. Any and all letters are hereby revoked. And the court will ask our probate court investigator to do one final report and file it into the case.
The court is setting its own due date of April 27th for the orders due, Your Honor.
All right, well taken.
Page 2, number 3.
This is the estate of Anselmo Jesus Robledo, cause number 2020 PB 755L2.
No parties present online or in person.
The court, right, yesterday, the court is granting the continuance, but also setting this case for inactive docket until further orders from the court.
Page 5, number 11.
The estate of Raquel Mandetta, cause number 2025 PB 522L2. Marcel Knotts and David Garcia, Daniel Mandetta. Any persons present?
No parties present in the virtual or physical courtroom. An inventory was filed, Your Honor.
Court will receive and review that and approve it if in order.
Page 7, number 14.
Direct Merchant Funding LLC versus American Transport Line LLC, DBA American Transport Line, and Fernando Herrera Macias. Cause number 2024 CVF 56L2. Attorney Bruce Johnson or any parties. Anybody present on this case?
Nobody present online or in person.
This case is set for dismissal. This case is dismissed for want of prosecution. The court will prepare its orders.
All cases have been called once, Your Honor.
First contested matter in this
Family docket would be page 1, number 1, with Ruben Arce and Juan Garcia, Your Honor.
Raul Agustin Gonzalez versus Lizeth Lopez Gonzalez, cause number 2015 CVG 561C3. Court marks Mr. Garcia present by video conference, Mr. Arce present by video conference, Ms. Soto present in person, Mr. Gonzalez present in person, and Ms. Gonzalez present in person. Counsel, what if any announcements do you have?
We have an agreement, Judge.
Go ahead.
We were here for temporary restraining order and temporary orders, Your Honor. Prior to this, we had asked that an attorney ad litem be appointed, Judge. Ms. Soto was appointed, Your Honor, so we all have come to an agreement as to what we believe is in the best interest of the child at this time, Judge. Temporarily, Your Honor.
And who will be telling the court the agreement?
Judge, I can go ahead and explain the agreement to the court. This is stemming from a modification that was filed by my client, Ms. Lopez, Your Honor. Some issues had arose in reference to the visitation between father and daughter, Judge. And the way we're addressing it this time, Your Honor, temporarily, we're asking that daughter continue with current counselor, Judge. She's going to counseling, but that she go to family counseling, that father also attend family counseling, and at the request of the counselor, or when the counselor believes it to be in the best interest of the child, that he initiate visitation between father and the daughter, Judge. And we're asking that this be done from now till we come back on final orders, Your Honor.
Mr. Garcia?
Yes, sir. Those would be the agreement, and also we did speak about maybe so that Ms. Soto's role can change from attorney ad litem to guardian ad litem.
Any objection?
Judge, we have no objection. I know that Ms. Soto's already met with the child and parents, and we do trust in her guidance, Judge, as far as her being the guardian ad litem, Judge.
All right, by agreement, the request to make the conversion is approved. Who will be filing the conversion appointment orders?
I can file them, Your Honor.
All right, those orders are due to the court honor before.
Is March 30th okay?
That's fine. Your Honor.
All right, March 30th. Anything else to put on the record?
So just one thing as the now guardian, can I act as a guardian ad litem now, Your Honor?
Yes.
So I did meet with a child. I've reviewed some of the CPS records, the border region records, and I've met with both parents. Both parents provided me some names of people that they want me to speak to. And I do want to continue that part of my work by interviewing all the relevant parties. If I need an earlier setting, may the court entertain, does it have to be by Rule 11 since I'm the guardian ad litem, or do I just request do an advisory to the court requesting that, or?
If it becomes necessary for the court to modify the visitations?
If I would want to make a recommendation for a modification to the current temporary order.
Oh, I see. Yeah, a simple advisory requesting a setting on the court will grant based on that. Mr. Garcia, Mr. Arce, I was hesitant to approve because it's contingent on a third person, an outside entity dictating when visitation should occur. But since these are temporary orders, it's going to be very easy. And my concern is that it's going to be non-enforceable because there isn't a specific date. However, it's going to be very easy for the person not in compliance to argue for or defend against it. If the counselor recommends in writing that visitation should happen. So if the counselor recommends visitation, make sure it's in writing. That way it can be enforceable between now and the date of the final hearing on June the 2nd. Does that make sense, Mr. Garcia? And Mr. Arce?
Yes, sir.
All right, there it is. Any other part of this agreement? All right, this agreement is due to the court in due form, honor before.
March 30th by submission.
Mr. Gonzalez, the court has approved the request. Do you have any questions for the court?
Not at this time, sir.
Do you have any questions for the court, Ms. Gonzalez?
No, sir.
Keep in contact with your lawyers and continue to make yourselves available to Ms. Soto, the court's appointed guardian ad litem. I wish you both very well. Have a good day.
Your Honor, final hearing in person or hybrid?
I think the party should be here in person. So ordered. All right. Good luck to all.
Thanks, sir. Thank you, Your Honor. Have a good afternoon.
It's good to see you, Mr. Garcia. It's good to see you, Mr. Arce. Have a great day.
Thank you.
Thank you.
Is Counsel Jose Arce, page 2, number 3.
Felicitas Garcia versus Brian Alvarez, cause number 2026, PBA 254C3. Court marks Mr. Arce present in person. Felicitas Garcia is present in person. Brian Alvarez, are you present? Court marks both parties present. Mr. Arce, what is the announcement?
Judge, we have an agreement,
What is the agreement?
Your Honor, with regards to, and for the record, Judge Jose, I'm making an appearance on behalf of petitioner Felicitas Garcia. There are two children before the court, AA and MA. Parties have agreed, Your Honor, that they both be named as temporary parent, joint managing conservators, with the petitioner, Ms. Garcia, having the exclusive right to designate the primary residence of the children. With regards to access and possession by the respondent, parties have agreed, Your Honor, to that Mr. Alvarez have access and possession on the first, third, and fifth weekends of each month, on Saturday and Sunday from 1 p.m. to 6 p.m., and also, Your Honor, on every Wednesday of the week from 6 p.m. to 8 p.m. Now, with regards to pickup and drop offs, Your Honor, surrender and return of the children, parties have agreed, Your Honor, that that be done on, at least on behalf of the respondent by his mother, Rosalinda Luna, and that the surrender and return of the children take place at the Walmart located on Zapata Highway. And I guess where the Melrose store is located.
Where the what store?
Melrose.
Understood.
Melrose. Judge, with regards to also as far as visits or access, parties have agreed, Judge, that for the Easter, which is coming up, the Easter weekend, that Mr. Alvarez have possession or visitation on that Saturday from 1 to 6 p.m. and that Ms. Garcia is going to have possession of the children on Easter Sunday. Now, with regards to the support, let me take that back. There's also any kind of communication with regards to the children is going to take place via the post app. And then with regards to child support, parties have agreed that respondent paid to the petitioner, Ms. Garcia, the weekly amount of $132.21 beginning on this Thursday, on March 19th, and to be paid every week thereafter. As far as access, Mr. Alvarez will be allowed to be able to visit with the children starting this Wednesday from 6 p.m. to 8 p.m. With regards to medical support, the children are presently on Medicaid, Your Honor, so Mr. Alvarez has agreed to reimburse the state of Texas in the amount of $50 per month. And I don't know, only one of the children is it him? The youngest judge is has the ACA, the Affordable Care Act, to Amber, and I believe Ms. Garcia pays the amount of $29 monthly, which Mr. Alvarez has also agreed to reimburse to Ms. Garcia. There are some property matters, Your Honor. Ms. Garcia has in her possession presently a 2019 Nissan Rogue vehicle, which she will retain possession of. There are also some amounts that Mr. Alvarez has agreed to pay, and those amounts are $614. I'm sorry, $600.14, which is owed to Hillside Crossing Apartments, and also the amount of $343.58, which is an overdraft that is owed to Wells Fargo Bank, and Mr. Alvarez has agreed to pay those amounts by before April the 15th of this year. And lastly, Your Honor, Mr. Alvarez has agreed that the temporary restraining order be converted into a temporary injunction. And I believe, Your Honor, that's going to be the extent.
Ms. Garcia, Mr. Alvarez, would you raise your right hands, please? Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes.
Both have answered yes. You may lower your hand. Is your true and correct name Felicitas Garcia? Ms. Garcia, you're joining us live. Your lawyer's on your right. Did you hear the agreement that was told to the court by your lawyer? Is that your agreement with Mr. Alvarez? Is that your full agreement? Was anything left out? Is there anything you want to change? Do you believe that this agreement is in the best interest of your two children? Same questions to you, Mr. Alvarez. Did you hear the agreement that was told to the court by Mr. Arce, Ms. Garcia's lawyer?
Yes.
Is that your agreement with Ms. Garcia?
Yes.
Is that your full agreement?
Yes.
Was anything left out?
No.
Is there anything you want to change?
No.
Do you believe that this agreement is in the best interest of your children?
Yes.
One final question, Mr. Alvarez. You're here without a lawyer. Did anybody force you to enter into this agreement?
No.
All right. The court hereby adopts and approves your agreement, finds that it is in the best interest of your children. These temporary orders are due to the court honor before
March 30th by submission.
Anything else on this case, Mr. Arce?
Judge, I just want to add one more thing. Just one, add one more thing, Judge, and it's something I've also discussed with Mr. Alvarez. It shouldn't be an issue. That, of course, anytime that children are picked up and returned to Ms. Garcia, did that that the vehicle be equipped with appropriate car seats for both children.
Any objection, Mr. Alvarez?
No.
So ordered. Put that into the orders.
We'll do that.
Ms. Garcia, do you have any questions for the court? Mr. Alvarez, do you have any questions?
No.
Does the court have Mr. Alvarez's email address?
No, Your Honor.
Mr. Alvarez, what is your email address?
It's Alvarez Brian 118 @gmail.com.
Please spell Brian.
So it's BRAYAN.
All right. Ms. Garcia, Mr. Alvarez, I wish you both well. We'll see you on May the 19th for your final hearing. More importantly, I wish your two children all the best. Have a good day.
Person?
Yes, make sure you're present in person, Ms. Garcia and Mr. Alvarez. Good luck.
May I be excused?
Good to see you. Good to see you. Have a good day.
Page 7, number 19 with Counsel Hernandez and Counsel Wells. There's also an agreement.
Good afternoon again, Judge.
Page 7, number 16, Your Honor, my report. 15.
Thank you. This is American Express versus Cesar Cabello, cause number 2024 CVF 70L2. Court marks Mr. Hernandez present in person. Mr. Wells also present in person. Mr. Cesar Cabello was present by video conference. Are you still present, Mr. Cabello? Court marks Mr. Cabello now not present. Counsel, what is the announcement?
Judge, we discussed this since the court was called the case the first time, and the plaintiff and the defendant have agreed to enter an agreed judgment for the amount sought in the pleadings and cost of court. And the amount sought in the pleadings is $28,876.58. So the principal amount cost no post-judgment interest, and we would request an entry date.
Is that the agreement, Mr. Hernandez?
That is correct.
This is a binding and now enforceable ruling of an agreement. It's stated on the record and agreed to by all persons. This is approved. These are the orders of the court, and those orders are due to the court honor before
March the 30th by submission. And
That-
may we remove the dismissal hearing on the 19th?
Yes, that comes off of the docket. Is that sufficient time to draft and file these orders, Mr. Wells?
It should be, Judge, but if we could get another couple of weeks, that'd be great.
Give us another setting, Miss.
April 27th.
All right, and it's just a submission deadline, so no need to come to court. Just get them on file, circulate them, get them signed by all, and file them on or before April the 27th. Anything else on this case, Mr. Wells?
No, Your Honor.
Mr. Hernandez? Thank you both. Have a great day.
Thank you, Judge.
Next is Counsel Garcia Davalos and Lisa Soto, page 3, number 6.
The estate of Armendina de los Santos, cause number 2023 PB4 1010108L2. Court marks Mr. Davalos present in person, Ms. Soto present in person. Fernando Martinez, are you still present?
Yes, Your Honor.
You were present in person, now you're present by video conference. Court marks you present and participating by video conference. Counsel?
Yes, Your Honor, we did confer, and Mr. Davalos has agreed if I can just have a couple of more or a week to revisit the final accounting that he provided with my client, and they did confirm that a check that my client believes may have been at issue was actually never sent. It was one check for $43,000 that my client has already received and cashed with no other funds.
Yes, that's correct.
So other than the motion for accounting, what else is pending?
I think that's it. As Mr. Garcia Davalos did also provide me with a document, a waiver, a release. If my client doesn't have any objections to the accounting, then I should be ready to close.
Yes, and I also filed with this accounting, Your Honor, waivers from all the other, I guess, heirs. So the only one pending will be from the,
Yes.
Ms. Soto's client, and we could be done with this matter.
So let's do this, and then I'll make a ruling, and then I'll give you some time to chime in. Orders are due on this case on April
27.
by submission, and what the court is looking for, either Mr. Garcia advised the court in writing that you've received the information and it's satisfactory, or in the alternative, send a fiat setting your motion for accounting again, or file anything that you want into the case, dismissals, agreements, judgments, orders. If nothing is filed, then I'm going to place this case on the inactive docket, but at least that gives you time to receive, review, confer, negotiate, and then either reset with a fiat that motion for accounting, or whatever it is that you need.
Yes, yeah, it was actually filed from Ms.
I
Martha,
filed a
so
motion for accounting just so then he filed that accounting report.
then it's really her, will be.
Yes.
Sorry, in reverse.
Yes.
So you file whether if you need that setting.
And that should be plenty of time, Judge. We should probably get it wrapped up before that date.
All right. Well, I wish all sides very well. Anything else on this case?
No, yeah.
No, Your Honor.
It's good to see you all.
Thank you.
Have a great day.
Yeah, thank you, Honor.
Well, I just may I be excused?
Yes, have a good one.
May we-
Yeah.
Yes, Mr. Martinez, have a great day.
Next.
Sorry, my apologies on the earlier case, Your Honor. I meant no disrespect about, there was on my fault, the scheduling, but nevertheless, I'm moving on that case. Your Honor.
I appreciate that. Thank you, Mr. Garcia.
Next with an agreement is Counsel Silverio Martinez and Counsel Maricela Rangel, page 3, number 5.
The State Benita Sanchez, cause number 2022 BB 472L2. Court marks Mr. Martinez present and participating by video conference. Ms. Rangel present in person. Ms. Maria Guadalupe Macias present in person. Counsel, what is the announcement?
Your Honor, we have been able to confer, and I was advised of a fact that I was not aware of, upon which my motion relied. We were alleging a conflict of interest. The facts that gave rise to that allegation have been or have disappeared. So our motion, our request is now moot. And that fact, Your Honor, was the fact that the respondent to this motion, Ms. Benita Magaña, was allegedly living on the property. She's no longer living there and nobody's living there. The property is up for sale. And so we're in agreement that this has become moot. We just wanted to make sure that we put on the record that she does not live there and will not live there and is not being occupied by her in any way, shape, or form.
Ms. Rangel?
Yes, Your Honor. Obviously, I know, and I talked to Mr. Martinez about this. While I know we differ on the issues of the conflict that may have existed before while Ms. Magaña was living there on the property. She had lived there actually since 1990, Your Honor. But rather than getting into that issue, I did tell Mr. Martinez that obviously Ms. Magaña moved out of the property approximately, I think it was end of November 2025, early December 2025, when it appeared that the property was actually going to be sold. She's no longer living there. She does not plan to return back to the property. I know in our filings, we address some of the issues with regards to the house and the condition in terms of those issues. But again, we have no intent. Ms. Magaña has no intent of returning back to the property with herself or Ms. Diana Sanchez, who she was residing there with her sister. There is no issue, Your Honor, at this point in relation to what Mr. Martinez felt was a conflict.
All right. Anything else to put on the record, Ms. Rangel or Mr. Martinez?
No, Your Honor, believe not. And we're hopeful that we're going to be able to sell the property. I think we've been trying. It's just a one-piece property in this estate. We're hopeful that there'll be a buyer soon enough that we can proceed forward and that all the heirs will get their fair share pursuant to the will.
That is correct, Judge. We will be in contact with Ms. Maricela Rangel and I regarding the process of that sale process. I guess however we're proceeding with that.
Right, in cause number 2022 BB 472L2, the court finds that motion to remove is now moot. These are the orders of the court. The orders are due honor before him.
March the 30th.
All right. So
I don't think we'll have an order, Judge. We're just not urging our motion, so I don't think it's going to be an order denying it or anything like that. Would it? Denying it as moot? Would you like that?
But it's not really denied, because I mean, at some point
Right.
it may have been viable. I don't want to make a finding because maybe it
Right.
was, but it was never proven if it was true. So I'd rather make some definitive statement in writing in the docket, I think moot is the way to go. It can't be dismissed, it can't be denied, it can't be granted. I think your all's agreement here that it's moot is the most appropriate thing.
Would council prefer April the 27th?
Either date work, Your Honor. I think that we put a one statement document. I don't know if the court wants us to each sign it or what the court would prefer, or just to submit it.
Just a minute, just a brief finding that matter, that way there's a filing and an order corresponding to that filing. All right, so all right.
So it'll be sort of like a court finding or an agreed finding that the alleged conflict issue has become moot, and that unless somebody goes back to live there or anything like that, that issue is no longer present.
Right.
We'll put something like that together.
All right, sounds great.
All right.
Thank you, Mr. Martinez. Thank you, Ms. Rangel. Ms. Macias, do you have any questions for the court?
Ms. Magana.
Excuse me, Ms. Magana, any questions for the court?
No, Your Honor.
I wish you all the well. I wish you and everyone all the best. Have a good day.
Maybe I excuse that.
Yes.
I think.
Yes, have a good day.
Thank you.
Thank you very much, Judge.
Yes, sir. Have a good day.
Contested hearing with Council Morris and Council Barrera, page 7, number 16.
2025 CVD 44L2 Brogo Transport versus Interflet Brokerage. Mr. Barrera is present by video conference. Mr. Morris is present by video conference. Mr. Barrera, are you ready to proceed?
Ready, Judge.
Who is your first witness?
It's not my motion, Judge. I represent the defendant or the plaintiff counter defendant, Brogo Transport. We're responding to the defendant counter plaintiff's motion for summary judgment.
I'm sorry, this is your motion, Mr. Morris?
Yes, Your Honor.
Go ahead. Who is your first witness or what is your argument?
Yes, Your Honor. I would like to formally offer our exhibits A through F, which were attached to our motion for summary judgment.
It filed into the case.
Yes.
Any objection to the court receiving those, Mr. Barrera?
No, Judge, not this time.
All right, A through F are admitted.
Well, thank you, Your Honor. So if I may, I'd like to begin with our traditional motion for summary judgment for Interflet's claim for conversion.
Go ahead.
So this is a hostage equipment case, Your Honor. Interflet Brokerage, as a freight broker, hired Brogo Transport, a motor carrier, in September 2024 to transport 6 shipments. Interflet also provided Brogo 2 trailers for those shipments, and those trailers were never returned. The payment terms were net 30. This is shown in both Interflet's rate confirmations that all listed for all 6 shipments listed 30-day payment terms. This is in our Exhibit A. If you'd like to see them, we can pull them up. But it's 6 pages. I believe they're in the Case Center software. If we need to pull them up, we can pull up the first one. It's on page A26, just as an example.
Are you asking the court staff to prompt Exhibit A?
We don't need to. I can move on. If it gets contested, we can pull it up. But it's there. The 30-day payment terms.
All right.
And Brogo accepted those payment terms. We have it. Their invoices that they submitted to Interflet also show 30-day payment terms. And despite these 30-day payment terms, Brogo began demanding quick payment already in September. So these are September. This is September work. Even before the invoices become due, we have these demand for payments. With this work, the equipment hasn't been returned, and the first invoice didn't become due until October 10. And yet they're demanding payment. They're coming after my client for payment, and we have satellite data. This is our Exhibit D that shows that the equipment was being utilized for non-Interflet purposes as early as October 1, and it was being used consistently through October 21st. Before the tracker was disabled and we could no longer see what was going on with that equipment. So After this, in November, so informally, Interflet had asked for return of the equipment, but now November 16, Interflet formally sends notice that and demand that the equipment be returned, that there's this loss of use that's accumulating, calculated as $75 per day per piece of equipment based on the revenue they had generated in the 6 months before. And well, that demand was refused. The equipment was never returned. And so we have all the elements for conversion here. Brogo's actions, as they exercised possession over Interflet's property, they had no authorization. There was no lawful basis for this. It was inconsistent with Interflet's rights. They received the demand, or they were given the demand, and they never returned the property. So beyond just the timeline, we already have, even before those invoices were due, they were already using the equipment for their own purposes. But beyond the timeline, we have the issue that their use of that equipment, or their retention of the equipment even, was unlawful and unauthorized, right? The taking the equipment hostage is unlawful self-help, right? So the Texas Supreme Court has explained, this is a bedrock principle. I have the citation. It's Wyseth v. Lax Stores. This is a Supreme Court case from 1971. So this is kind of bedrock stuff. And they're a lien holder, right? So a lien holder, this is somebody who has had a legal interest in some of a debtor's assets. They went ahead and took possession of non-liened assets, and the court said, that's unlawful, right? You have to have some basis for this taking, and that was even in a situation where they had a lien. It was just over, over something very specific. So here, absent authorization by statute or agreement, this self-help, again, this taking the equipment hostage just because they felt unsecured does not legally excuse the conversion. So that's the argument. Thank you, Your Honor. I'll cede my time to counsel, reserving the right to rebuttal.
Response, Mr. Barrera.
Thank you, Judge. Judge, just to give you a little bit of background about the facts. Back in September of 2024, Interflet contacted my client, Brogo Transport, the owner of Brogo Transport, Armando Gonzalez, regarding 6 loads that they were wanting Brogo to transport to all across the country, really 3 different states: Texas, New Jersey, Florida. Armando Gonzalez, the owner of Brogo Transport, was concerned about accepting the loads from Interflet based on a history of them taking well over 30 days to pay for the services that the carrier provides. So as a condition of accepting the loads, he required for Interflet to pay via Quick Pay, which is a platform for paying truckers. Interflet agreed to pay via Quick Pay, and as evidenced by the text messages, which I attached to my response to their summary judgment as Exhibit F, paying by Quick Pay usually takes about 48 hours to a week. Brogo Transport transported each of the 6 loads, like I said, 3 different states: Texas, New Jersey, Florida, all during September 2024, and began asking for payment. As shown in the text messages, each time he asked for payment, Interflet never complained about the services that he provided. There was no deficiencies or delays with the transporting of the goods that he transported. All they told him was, your check will be ready next Friday. Your check will be ready next Friday. And when my client reminded them, as shown in the text messages, that you have to pay via Quick Pay, as was the agreement, they never disputed that. It wasn't until my client waited 3 months in December of 2024, 3 months after, when he still had not received payment, he filed a claim in the Justice Court, where he obtained a judgment from Judge Salinas for the full amount of his services, which was 15,900 plus court costs, which came out to about $16,150. Now, both parties, as I understand it, I was not involved at the time when it was a small claims court, but as I understand it, both parties were pro se. But when my client obtained that judgment, which is the basis of this case now that we're on appeal, my client understood that Judge Salinas ordered for interflat transport to pay the $16,150, and at that time he was supposed to return the trailers. They have not paid, so my client is really just following the judge's orders as he understood them. So in order to approve conversion, you have to show that they wrongfully possess the property. He's not wrongfully possessing the property if he's following the judge's orders. The other thing I would add, Judge, is we asserted the affirmative defense of proportionate responsibility, which applies to any tort, including conversion. Basically saying, had interflat brokerage paid these services at any point, really, they would have gotten the trailer back, and none of this would have happened, and none of us would be here. It was their refusal to pay without any cause that has caused this cause of action to occur.
Anything else from any person?
Well, Your Honor, if I may just respond to that last line. So I definitely sympathize with Brogo. So we mostly represent motor carriers, and we see these issues regularly. And there's a right way and a wrong way to handle these disputes. And taking equipment hostage, it's the wrong way. I mean, federal law mandates that brokers have surety bonds exactly for the situations. When a carrier is feeling unsecure, they know that there's a broker bond. There's shipper consignee liability. Allowing equipment to be taken hostage, it's going to grind everything to a halt. That's not the answer. And so again, just the argument is this wouldn't have happened if Interflat wouldn't have done this. Well, Interflat could have had an obligation to pay that same day. And that doesn't somehow create a legal right to hold equipment hostage. And just the second issue was the peace court judgment. So two things there. I believe it has been submitted as an exhibit in both my motion and if not in mine, definitely in theirs. The motion doesn't mention anything about this kind of exchange. But then secondly, it was suspended by operation of law, right? With the appeal and the security being provided for the appeal. So if that shouldn't constitute a reason to hold on to equipment, right? The broker here had the security of a bond. So any argument that somehow the conversion ceased at that moment or the damage is no longer applied, I would point to again, it wasn't part of the written order, and that judgment was suspended on appeal.
I think the last part is where the court is stuck on in terms of what you all both have argued, because Mr. Morris made his argument, but then in response, Mr. Barrera said, well, my client was relying largely in part on some order. That order is just as the peace order that is not in effect at the time it is appealed. So I mean, I guess the best way I could describe it is it's a defense, but it's imperfect because it no longer applies once appealed. Interesting. All right. Anything else from any person on this matter?
So we do have the no evidence portion of the motion for summary judgment. It's similar. We're still kind of getting into issues of what the arrangement was between the parties. So if I may, Your Honor.
Sure.
So on the no evidence motion for summary judgment, we are challenging Brogo's claim of breach of contract, and we're challenging it because well, the argument is for them to prove breach of contract, they need to establish that they performed the contract, and delivery of the equipment is part of the contract, and so the contract wasn't performed. And there's been an argument with the rate confirmations and delivery paperwork, just saying, okay, you need to take this to a certain location, and all of that was satisfactory. And we don't dispute that. We don't dispute that we've never raised an issue with the delivery of the cargo. However, just because the paperwork is silent on the equipment, it doesn't mean that the equipment doesn't need to be returned. Right. The paperwork may be silent on the issue of you need to return the equipment by such and such date at such and such place, but that doesn't mean that it isn't part of the arrangement, regardless of any silence of the document. So we have a case on this. It's a case out of the appeals court in San Antonio from 2010. This is FFE Transportation Services versus Martinez. And it's a similar case. There's a freight forwarder there who took receipt of cargo that was loaded onto a trailer. So they took receipt of both portions. And the cargo, that went ahead and got delivered. The freight forwarder took care of that. Everything was fine. The trailer, however, was not. The trailer was stolen from the yard, so they weren't able to return it. And as their defense, they said, hey, we received that with a bill of lading, a type of delivery receipt. And they said the bill of lading just said, get this cargo from point A to point B. It didn't say anything about the equipment. We never accepted responsibility for your equipment to the customer. And the court said, hey, the paperwork could have been silent about this, but that doesn't mean it wasn't part of the arrangement, right? It wasn't part of your obligations to return that equipment. And so even in the absence of express terms between the parties, it doesn't mean that there isn't some kind of responsibility. And so it defies law, and it just defines the ordinary course of these things. If you're given some equipment, you return the equipment. And then we kind of circle back to what we were talking about a little bit earlier. Where is the justification for holding the equipment hostage? It's entirely missing. And while again, I sympathize with the feeling like they're maybe not going to be paid, or there's some doubts about that. The law doesn't allow for this kind of self-help.
Response, Penny?
Thank you, Judge. This one's simple, Judge. This is a no evidence motion for summary judgment. Under Texas Rules of Civil Procedure, there needs to be adequate time for discovery. We just filed our answer on this case last week. There has been no discovery. Any motion for summary judgment, no evidence motion for summary judgment at this time would be completely improper and contrary to the rules. But apart from that, his no evidence motion is also faulty in that it seems to be arguing that if my client breached the contract, then they no longer have any claim for breach of contract against the other party, which is not correct. And then apart from that, we provided in our response ample evidence that they did fully perform and that Interflat breached the contract. So I'm referring to the invoices that Brogo sent after they transported the load orders, the load confirmations, the bills of lading for each load, the master invoice, and the text messages going back and forth between both parties where my client is trying to get paid for months and Interflat continues to give him the runaround. So I don't think there's any basis to grant a no evidence motion for summary judgment.
Well, several questions. First question, and I guess you raised this issue, Mr. Barrera. Mr. Barrera, you made an argument to the court regarding the no evidence motion for summary judgment that sufficient time hasn't elapsed for the court to hear this case, sufficient time for discovery. This case was filed May 12, 2025. What is the argument that sufficient time hasn't elapsed for the exchange of discovery in 10 months?
The argument is, Judge, that this is a LLC. LLC needs to be represented by an attorney. Brogo Transport was trying to represent himself pro se. I believe he's appeared before Your Honor several times. He finally retained us. I want to say a couple of weeks ago, and we filed our answer about 1 week ago. So as far as time for discovery, there has been no discovery conducted whatsoever now that both parties are represented by counsel.
Has the court been made apprised of that with any written motion for continuance on either the final hearing, which is set for today, or on the motions for summary judgment, either or?
No, Judge, we have not filed a motion for continuance. We were going to send our discovery request to Mr. Morris and begin discovery process.
But how could you do that? Because if you were retained a couple of weeks ago, even if you would have done that the day after, it's due after the final hearing, unless you file something, no?
Judge, it's my understanding that we're here to hear Interflet's motion for summary judgment.
Well, there's three settings set on the court's docket today. You're set for a final hearing, and then because motions for summary judgment were filed, the only date that the court could give was to set those on the date of the final hearing. It would be a moot point to set them afterwards, so the court set them all on the same day without having to extend other deadlines. So you're set for final hearing, which is why one of the first questions the court asked was, are you ready to proceed? And who was your first witness? Ostensibly, I thought you all were going to hold the final hearing, not argue the MSJs. I guess that's the court's first question. The second question is, I was in review of the court docket sheet. I was looking and reviewing the response. The response is filed March 11th, which is 6 days before this hearing, or 5. 6, because today's the 17th. That's outside of the response window. Is there any motion for leave for the court to consider those responses?
No, Judge, but I do not believe that Interflet has objected to the late response. And it was filed 6 days before, but only by about 2 hours. I finished preparing the response. Like I said, we were barely retained. I was, working on some other cases. And I finished our response at about 10 p.m. and my paralegal tried to file it, but she wasn't able to until about 1 a.m. So it's by about an hour, but I do not believe that Mr. Morris has objected to the timeliness of our response.
We have not objected in writing, Your Honor.
Say it again.
We have not objected in writing, Your Honor. There's no filing on our behalf for challenging the late filing.
I know you don't object. The question is, can the court consider without leave? I mean, there's rules governing when these things are said and heard and supposed to be responded to. If those things aren't met, then certain other things and conditions should be met under the rules of civil procedure. And I'm just wondering whether any of those conditions have been met for the court to properly and appropriately consider the responses that were late filed.
Understood, Your Honor.
Oh, and I do see that you are right, Mr. Barrera. The timestamp. I was just looking at the date as 1 day late, but I'm looking at the timestamp, and it is in fact at 1:10 a.m. You're right. I hadn't seen the time, just the date.
Yes, Judge, and I would ask for a little leeway, and I'm happy to file a motion. I know we're already hearing these arguments, but we just filed our answer. As a matter of fact, we filed our answer to the counterclaims that same day. We were retained shortly before that.
Yeah. Well, I tell you what, let me consider the motion, the traditional motion, the no evidence motion. I mean, so the response time, I understand number one, there's no objection. Number two, well, number one, there's no motion for leave. Number two, there's no objection. But number three, I mean, so you should file, and you did, but you don't necessarily have to, because these things have to stand or fall on their own. But I tell you what, let's do this. I'm going to self-impose a deadline on the court for the court to receive, review, and consider this. And I've already heard the argument. I'm just going to rule on this by submission at this point. The orders, I'm going to give myself the deadline for the orders due date on April
27th.
All right, so you'll have an order. Mr. Morris, do you have an order granting both motions?
Yes, I do, Your Honor.
Mr. Barrera, do you have an order denying both motions?
We should have submitted those, Judge. If not, I will make sure that they're submitted by the end of the day.
All right, so double check and confirm. If they aren't there, file them in. I'm going to sign one or the other on or before April the 27th. If the court denies both motions, then you'll come back for a final hearing on
How many days out, Your Honor?
at least 3 to 4 weeks, at least minimum, 21 to 30 days after, if not more. Give me a date after April 27th.
June the 9th at 9 a.m.
All right. Thoughts, questions, comments, objections, Mr. Barrera?
No, Judge. Not this
Mr.
time.
Morris?
No, Your Honor. Thank you.
All right, we'll see you here on June the 9th if both motions are denied. If not, that will conclude that case at that time. I wish both you very well and your clients.
Thank you, Judge.
Thank you, Your Honor.
All right, have a great day.
Thank you.
Okay.
Likewise.
All cases have been called, Your Honor.
Right, that now concludes this docket held in person and by video conference for Tuesday, May 17th, 2026. The court continues to embrace the latest technology to provide safe and uninterrupted access to justice without delay. Today's docket was made possible by the appearance of counsel and parties and by the assistance, diligence, and preparation of the Webb County Court of Law 2 staff and the employees of Webb County that provide judicial support to the court. I wish all persons well. Have a great day.